Hey, 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 all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now say the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, everyone. My name is Vicki Henry, and I'll be your panel chief today, and my pronouns are she and her and judge. I'm delighted today to be joined on my right by Judge Smyth and on my left by Judge Toone. The rules today and always in the appeals court are that each side has 15 minutes for their argument, for better or for worse. We do not allow rebuttal. You may see that we all have these giant iPads, so if we're looking at our screen, it's because that's where all of your briefing is and all of the record, and it can be helpful in our questioning and discussion with you today. With that said, we will start with our first case. We have 6 cases on today, Commonwealth versus Ferrera-Artour.
Good morning, Your Honors. My name is Hayne Barnwell, and I represent JULIO Ferrera-Artour. My plan this morning is to focus on the knowingly element, integrating issues 2 and 4 in the brief, and hopefully reserving just a little bit of time to discuss issue 3, which is the Guardado error. As far as the knowingly element, the Commonwealth had major gaps of proof, such there was insufficient evidence on this element. There was no testimony from the first officers who arrived on the scene. Once Officer Entwistle and Officer Rooney arrived, the defendant was already detained with a blanket around him. So we don't know when that particular trash bag was opened or by whom. And this court in Ramirez instructs us that just because knowledge is available to a defendant doesn't mean that there was actual knowledge by the defendant.
What about the admission taking a firearm from the vehicle?
That came after his arrest and after Officer Entwistle actually took out the gun, the alleged rifle, and cleared it. So at that point, he knows he's under arrest. I think the only fair inference is that he sees that there's this gun, and he didn't spontaneously say, I got a gun. The officer Santero asked him, where did you get the gun? Obviously referring to the thing that now he knows that he had all along.
So I take it what you're arguing is that we have no idea when the first officers got there if the garbage bag that was near him was closed.
Exactly. We don't know if it was closed or opened when the first officers arrived.
All we know is that a later officer, when he arrived, the bag was open and the barrel of the weapon was visible.
Not the entire barrel, but part of the barrel, and only after he illuminated the area with his flashlight. And so that's the other piece of this, that it was very dark. So we have...
There's no evidence that the officers that were on the scene were like, hey, we think he has a firearm?
I'm sorry?
There was no evidence that the first officers on the scene told the later arriving officer, we think he had a firearm?
Oh, like through hearsay? No, because those officers did not testify, and there was no hearsay evidence to that.
What was the state of the record, if you could refresh me, about whether the defendant was handcuffed when the later officer arrived?
He was not handcuffed at that point. He was sitting on the sidewalk with a blanket around him.
Right, but I guess that's
yes.
making me wonder whether, in fact, you are correct, because I don't know why police officers would allow someone to not be handcuffed when they know that there's a bag a few feet away with a giant firearm in it.
Well, the only thing they could testify to that is that they got the radio call. I mean, understandably, they weren't allowed to testify like, we got a radio call about a gun, right? So,
okay.
But they did say, we got this radio call, we got there. I mean, I agree with you. I think it would be better practice to have him handcuffed at that point, especially since he seems, frankly, out of his mind, intoxicated. But they didn't do that. Actually, it's kind of interesting. Officer Entwistle, and I don't think I pointed this out in the brief, so I'll point this out now. It's page 120 of volume 1 of the transcript. I just found this interesting that even he, and this is why they explain why they didn't put him under arrest right away. Officer Entwistle testified that, quote, Officer Rooney testified, quote, my partner Matt, that's Matt Entwistle, advised that this did not appear to be a fake or pellet or BB gun. So I was operating under the assumption that there was a gun on scene and placed the suspect under arrest. So that's interesting also because, you know, even if you see a little part of a barrel, even this police officer needed to do a bit of examination before determining, oh wait, this isn't like an air rifle or a BB gun. This is worthy of arrest.
How does that help your argument with respect to knowing possession?
Well, it shows even more so that, and I certainly would dispute this completely, but even if the Commonwealth sort of succeeds on its argument that he would have seen something in that bag, how does that defendant actually know that this is a rifle specifically as opposed to something else? And I think when you have a police officer on scene who doesn't even know right away, who doesn't even put him under arrest right away, I think that is significant. Of course, I already discussed he's highly intoxicated. There's also no evidence that he is familiar with guns or rifles particularly. Sometimes you will get statements from the defendant to that effect. We don't have that here. Even if this court found that there was sufficient evidence of the defendant's knowledge, I think one sort of maybe unique or interesting issue in this case is the intoxication instruction that the judge gave. And I think if the court finds that that was error, then the split verdict, I think, just sort of proves the substantial risk of a miscarriage of justice. Because when the jury is given the intoxication instruction with respect to specific intent, with regard to the breaking and entering count, they acquit. And so if he had had that intoxication instruction with respect to the other counts, I think there's a serious chance that they would have acquitted on everything.
But there was no request for that instruction, right? So it's substantial risk
It's a substantial risk, absolutely. But I think there's clear, I just think even the split verdict, the fact that he's just the evidence itself, he's extremely intoxicated, and also, excuse me, the judge gave a humane practice instruction. And also, there was a direct challenge to Officer Centeo's qualifications and the like. So I think that could have made a difference in this case.
Can you address, you didn't mention this is something you're going to address, but it's the first issue in your brief. So can you address the issue about the sufficiency of the firearm being a rifle?
Yes, I'm happy to go there. So I know that there's the case Commonwealth, I believe it's Commonwealth versus Harrison, where the court, I believe it's this court, concluded the expert went through the normal process for examining this firearm. Now, did the expert testify, yes, I fired this shotgun, this particular shotgun? No, but because you put together both, he's going through the proper process, and then you jump to, and he says this is a shotgun, you put those two things together, and then that makes a sufficient case that this is a firearm.
Right, we said there was enough there in that record that the trier of fact in the light most favorable to the Commonwealth could infer that he took all the steps.
Correct.
Right, so the question here is, and I not sure either one of you grappled with this, is in the light most favorable to the Commonwealth, and I want to emphasize that point for you, because they'll do it on their own, but you, light most favorable to the Commonwealth, is there anything in this record that lets the jury infer that he did examine whether there was a rifle bore?
No. And I think even the Commonwealth would concede that point, although I'll defer to them on that.
Well, they definitely conceded that he didn't state that he examined the weapons bore.
Correct.
And they will press them further about, they're kind of squishy on whether or not he gave the right definition. But did he ever say that one of the elements is that it has a rifle bore?
No, there was follow-up by the judge about, can you kind of explain more about like general differences? And he does say, well, generally, a shotgun shoots pellets and it has this smooth bore. And sort of generally rifles have rifle bore, but he never said that that was at all legally relevant to him. When the Commonwealth again and again keeps asking him, so what's the definition of a rifle again? How do you go through that process? He says, I think 2 or 3 times, a rifle is longer than 16 inches and it's capable of projecting a projectile, and that's it. So that implies that that wasn't legally relevant for whatever reason. It just was not relevant to him when he was examining this gun. And so that, I'm sorry.
So as I understand your argument, because here, this case is different from Harrison, because here the expert says, misdefines the rifle as including only 2 of the 3 elements. And so when he says this is a rifle, you can't reasonably infer from that it actually is something that satisfies all 3 statutory elements. Is that your argument?
Precisely.
Okay. And then what's now I guess the secondary argument for the Commonwealth is, well, it went back to the jury. So can you address whether the jury could independently make the finding as to the rifle bore from their inspection of the rifle?
So you can't see the rifle bore just looking at the gun. You would have to look inside the barrel I'm learning things myself about guns. So you actually have to get a bore scope, or at least, at the very least, a flashlight, and there's no indication that they were provided either of those things. I would personally be shocked if a court officer would even allow them to open the barrel or look inside.
Was there any evidence at all as to what a rifle bore is?
No.
That the jury could independently sort of say was there any definition of a rifle bore? Do you know what a rifle bore is? What's the definition?
I actually had to look that up myself. The judge does not, and I did, after briefing, I kicked myself because I should have, I think, also raised an instructional error issue. I did not raise that in the brief, but I think that's, even with sufficiency, that's part of the problem, that they don't know what does rifle bore mean other than it's a rifle bore.
What's your understanding of what it is?
I'm sorry. I'm sorry. The rifle bore is when you have lands and grooves. Sometimes, though, you can have polygonal rifling, I've learned, which is like hills and valleys. So it doesn't necessarily have to be grooved, but usually it is. And then the shotgun has that. I think smooth bore is self-evident what smooth bore means, but
it's the interior of the barrel. Is that correct? So
Correct.
You'd actually have to look and see some kind of grooving or other. I don't know what the alternatives are, but inside the barrel. And how would a layperson be able to do that, looking at a rifle?
Exactly. I don't see how you can. And I was actually looking for some sort of expert evidence that I could give you beyond my Wikipedia search. And you actually see that a bit with Detective Quintiliani, their expert. He actually, I think at one point he says, I'm sorry, I don't have the page, but he basically says, when I handle a gun, any kind of gun, I'm always assuming that it's loaded. I'm always assuming that it's loaded. So that's why I suggest to you that it would just be shocking if a court officer, even though you know in your mind that it's not loaded, you still want to be extra safe and just assume that it's loaded. That's why I would be personally shocked if any court officer, or any judge for that matter, would allow jurors to open up a barrel or manipulate in any way such that you're looking down a barrel. And again, there's no indication that, and if that had happened, I think the judge at least would have said, I am giving you a bore scope, or I'm giving you a flashlight, and with proper supervision, you will be allowed to actually look inside the barrel with whatever is a rifle bore.
Even assuming they were able to do that, how would they know what it is?
Exactly, and how would they know? That is the other problem with this, and that's why there's insufficient evidence. It's also an instructional error in the sense that there's an inadequate jury instruction on the issue, but I confess I did not raise that specifically, but that is, I think, also part of the sufficiency problem, that you just don't have any guidance on what a rifle bore even is.
Is this issue, I'm sorry.
No, go ahead.
Is this issue, so clearly applies to count 1 about the 10A charge. Does it apply as well to count 2, the 12D charge, about carrying an unloaded rifle in a public way?
Yes, because they still have to prove that it's a rifle.
And the definition of Chapter 140, 121 applies to 12D?
Yes.
Is there any authority for that?
this is a rare charge that's brought, so I don't know that I have a specific case that says that explicitly. However, the judge did instruct, I believe the judge instructed, just like I told you before, they have to prove that it's a rifle. That's my memory of the instruction, so that's kind of the law of the case anyway. But if I could just turn just very briefly to the Guardado error, I think the problem with the Commonwealth's brief on this is that the Commonwealth misapprehends the standard. The standard isn't whether there is sufficient evidence that he was unlicensed. It's a heavy burden. It's harmless beyond a reasonable doubt. And the guilty verdict must be, quote, surely unattributable to the error. The court can't be sure here because, again, the judge gave the humane practice instruction, so the jury could have disregarded his statements entirely. He was extremely intoxicated, of course, and there was just like in Burgos, and I realize it's an unpublished decision, but there was a direct challenge to Trooper Centero's, both the credibility and his qualifications to interpret, because he grew up in Cape Verde learning Portuguese, and my client only understands Brazilian Portuguese.
The trooper testified that your client didn't have a license to carry, correct? Right?
The
defendant told him he didn't have a license to carry.
Correct.
Right. Was there any testimony regarding an FID card?
None, no.
Okay. So what's your position then with respect to the ammunition charge?
Pursuant to Guardado 2, if we were in Guardado 1 land, I would say that it should be double jeopardy and it shouldn't go back at all. And it should be just a required finding. But because we're in the land of Guardado 2, it would be reversed, new trial along with the others. Thank you, Your Honors.
A follow-up, actually.
I'm
Are you essentially saying, back to the bore issue, that definition of bore is beyond the ken of the jury?
It's beyond the what, I'm sorry?
Ken, K-E-N, of the jury, that the average jury, reasonable jury, wouldn't know what a rifle bore is?
No, correct, that the average juror would not know. They need more guidance on that. I recognize that the model jury instruction, I think the model jury instruction just says rifle bore, but of course, model jury instructions are not law, and I think it would be very helpful if Your Honors could recommend more guidance on that through the jury instructions that are given to judges.
And my second question, unrelated, we may hear from the Commonwealth that the defendant's statement did relate to knowledge. Just remind me, the statement is not before us, the voluntariness, for instance. Was that challenged?
He did challenge that at trial. He frankly should have filed a motion to suppress beforehand.
What I mean is motion to suppress. There was none
There was
filed?
no motion to suppress, but the judge did give him the humane practice instruction anyway. So,
Okay, thank you.
thank you, Your Honors.
Thank you. We'll hear from the Commonwealth.
Good morning. May it please the court. Alyssa Hatfield on behalf of the Commonwealth. With me at council table is ADA Mackenzie Slyman, asking this court to affirm the defendant's convictions. The Commonwealth presented sufficient evidence for the jury to determine that the gun met the legal definition of a rifle.
So let's to break that down for a minute. You concede that the detective did not specifically state that he'd examined the weapon's bore, correct?
Yes.
So my concern with your citation to Harrison is that you glide over the part where we said in Harrison that there was enough for the jury to infer that expert had test-fired the weapon. What in the record allows this jury to infer that he determined that it had a rifle bore?
There is cumulative evidence that shows that the detective was aware of the legal definition of a rifle, including all three elements, one of which being the rifle bore.
I don't want to hear about the three elements. We want to hear about the rifle bore.
Yes. The court clarified in page 17 to 18 of the second transcript to confirm the difference between a rifle and a shotgun, at which point the detective stated that a shotgun has a smooth bore and a rifle has a rifled bore. Additionally, on cross, he was also asked what the bore of a rifle was. He defined it. He explained that it's the inside portion of the barrel from the muzzle to the chamber, and that a shotgun has a smooth bore, whereas a rifle has a rifled bore. I recognize that the definition of rifle rifled bore was not specifically explained. However, he did clarify that it's not a smooth bore. Additionally, the judge instructed the jury not once but twice in his instructions that the gun in evidence must meet the legal definition of a rifle and include a rifled bore, and that if the jury found that the rifle did not have a rifled bore, then they should not convict the defendant.
Right. So, but when the judge kind of, I think, showed some frustration with the expert, right, and sort of, I think at some point said, he called him a so-called expert because he said, it'd be one thing if he just sort of said, I looked at this rifle and it satisfies the statutory definition. But the problem for your case is that he defined what the statutory definition was, and he only said 2 of the 3 elements. And the judge had to kind of prompt him to talk about rifle bore. But even that, in that prompting, he didn't actually say, oh, yes, that's a statutory element too. So, and he didn't testify in any event that this weapon did have a rifle bore, right? So there's these gaps that we're trying to find out how can the jury have inferred that this weapon had a rifled bore from the expert's testimony when he never kind of makes any of those connections along the way?
I would say that in the clarification, when the court asked him about the difference between a shotgun and a rifle, that he stated, and additionally in cross, that it was clear the expert was aware of what a rifled bore was. I also argue that the jury can reasonably infer, based on the expert's testimony, whether they can weigh the credibility of the expert themselves as well, and knowing that a rifled bore was one of the elements they needed to look for, if they determined that the expert did not adequately testify to the bore being rifled, that they would not have convicted the defendant of that charge.
What is a rifled bore? Oh, sorry, go ahead.
No, you go.
What is a rifled bore?
Rifled bore, it's the inside portion of the barrel from muzzle to the chamber, and it has ridges and grooves.
Okay, but no one ever talked about ridges and grooves at trial, right? Those
Correct.
words, I don't think, are in the transcript, right? So how is a jury going to know, even if we assume that they're able to look down the barrel or I don't know, dismantle it, which seems improbable, but how are they supposed to know what to look for? Because rifled itself doesn't mean anything.
Right. Beyond they know that it is not a smooth barrel, but beyond bringing
smooth.
their own knowledge to of what a rifled bore is, they can simply say that if they found that they weren't either clear whether the rifle had a rifled bore or what it was, that they would have known from the judge's instructions not to convict the defendant, knowing that this was an element that the Commonwealth had to have proved.
Did this expert ever testify to all 3 elements for a rifle?
The expert initially mentioned the 2 elements about the barrel length and the operability,
Right,
and
that
then
was faulty, correct? 'Cause
correct,
you
and
br-
then later included that another difference is a rifled bore.
Not that it was a difference, but did he say it was a legal requirement to find that it was a rifle?
He did not.
So how do we know that when he says this was a rifle, how do we know he applied the right? Is there any basis that he applied the right 3-element test?
There is a basis that he was aware that that was a factor needed, even though he did not specifically state it was a legal statutory difference, that he knew that that was a difference, a defining factor of a rifle. Again, I testify that it is the jury to determine, based on the evidence presented, whether they found the expert credible, whether they found that the expert had presented sufficient evidence that the rifle contained a rifled bore.
So you say in your brief that the bore is a physical characteristic of the rifle, that one that can be seen to some extent by simply staring down the barrel of the gun. Are you representing to the court that you stared down the barrel of this particular firearm? or
No, Your
weapon?
Honor, I have
No,
not.
okay. So then what's the basis for that statement?
The basis for that statement is similar to that also due to external research and attempts to discover what the bore is, since it was not very clearly defined in the record, that it was not, it was nowhere did I find that it was necessary to have a flashlight or a borescope. However, the issue is not whether the jury had a flashlight or a borescope. The issue is whether, given the evidence that was in transcript, that was in record, the jury reviewing that evidence in the light most favorable to the Commonwealth.
So is the defendant correct that given the barrel length, this weapon could have been either a rifle or a shotgun?
The barrel length, I believe, was not the appropriate length for a shotgun, so there was not a question of whether it would be a shotgun. It met the barrel length for a rifle, and it also...
Meet the barrel length for a shotgun.
Your Honor, I don't actually know that specifically. I do know that he stated it was a rifle, and that he gave an accurate definition of the barrel length and its operability, and he did distinguish between a rifle and a shotgun. In addition, he also explained the difference between their operability between a shotgun and a rifle, not just simply the rifled bore aspect.
I'd like to direct your attention to Exhibit 6 that's in the appendix.
Yes, Your Honor.
What is it we're looking at here? Because it's very black and white.
Yes, I believe that Exhibit 6 is the picture of the, I don't have that picture in front of me at the moment, but I believe that one is the picture of the rifle or the magazine.
Well, I will show it to you, but...
Oh, yes. That is a picture of the ammunition and magazine. So what you're seeing...
But that's my question. Are these two magazine clips?
Yes.
How, when looking at this, and I have handled some firearms, how am I supposed to see that there are bullets in there? Like, where is that?
When viewed in the color photographs, it's much more visible that it is bullets, ammunition. However, I will also say that at the very least they're exposed. You can, if you were to handle them physically in person, you'd be able to tell that there was ammunition inside of them. You could feel that they were indeed full. What you're looking at is a full magazine with ammunition inside of it.
I thought he was found with 13 rounds.
He was found with I believe two magazines filled with rounds.
And they were both entirely full?
Yes, Your Honor. Additionally, on that note, I would argue that the trial judge, that there was sufficient evidence to find that the defendant knowingly possessed the rifle and the ammunition. The defendant did not need to know the technical elements that make a gun a rifle. They only needed to know that it was a gun within the conventional terms. The defendant himself admitted that when asked that he took the gun from an
Right, but I mean, her argument, which has some force, is that we didn't hear from the first officers on the scene. We hear from this officer who then lights up the area, and there's this barrel of something that's there, and the officer then asks him about the gun, and the defendant then, who can now at this point also see the gun, except that he's really, really intoxicated, takes up the defendant's language, but that in fact we have no idea, there's no basis to know what the defendant knew before the light, before the detective. We don't even know, that the bag was open. That's what she's arguing, I think. So what do you say to that?
I would say that if the defendant is admitting to having handled the gun, that's the information that needs to be shown. He does not need to know that it is a rifle within all of the three legal technical definitions of the rifle.
Well, but I think, let's put it a different way. Let's say that he breaks into a car and he takes a trash bag out of the car and he has not opened the trash bag. So and let's say there is a bunch of stuff in there, but there's also this weapon. Is he charged with knowing that he has a weapon when he hasn't opened the bag?
In that case, if he has not opened the bag and is not aware that there is a gun in there. However, the issue here is not whether
We'll
he...
finish that.
Oh, sorry. No, if he had the bag and did not know that there was a gun in the bag, that would be very different from the case at hand, which is not that he took the bag from the car, but that he took the gun and then put it in the bag after. Which is the distinction here. Additionally, the magazines were found on his inside pocket. They were not also found in the bag, which furthers the indication that he did not take a bag that was filled and then set it next to him, but he took the gun instead. There were 3 to 4 inches of the barrel gun pointing out, which also did indicate that an officer was able to identify it on sight alone, that it was probably a rifle, or that it was probably a firearm, at which case, when they took it out, then he was able to say, yes, I took that gun from an unlocked car. The defendant, as you mentioned, had some level of intoxication. However, this simply goes toward whether the jury could determine that he was knowingly possessed the rifle. It goes towards the jury's determination of his weight and credibility as well, so they were able to factor that in when they were determining his conviction on this charge.
So is the defendant correct that there was no evidence about whether or not the defendant had an FID card?
The defendant said that he did not have a license. There was not evidence in the record that the trooper asked him specifically if he had an FID card. There is evidence that...
What flows from that?
Based on the defendant's admission that he did not have a license, I believe the jury can reasonably infer he also did not have an FID card, as in that case, he would have likely told the officer.
For purposes of establishing beyond a reasonable doubt for harmless error analysis, you can infer from him saying, I don't have a license, that I don't have an FID. I mean, that's a total non sequitur, right? I think you have a decent argument as to harmlessness as to the firearm license issue, the license to carry, but he didn't say anything about an FID card. So how can you think that the ammunition charge can survive Guardado?
Specifically regarding to an FID card for ammunition?
Yes. Isn't that required under Guardado, an FID card?
I believe that simply having a license to carry would accommodate both the rifle and the ammunition, that there's not a separate card that you would need to carry for the ammunition. Particularly under Bookman, when the police officer testified that the defendant told him he did not have a license, then the court found that the error was harmless because there was uncontroverted evidence that the defendant did not have a license.
Right, but the charge is ammunition without a firearm identification card. So what is the basis to find that the Guardado error, which you concede exists, not to anyone's, not to blame anyone, but how can we say that's harmless error, if there's no evidence at all about a firearm identification card?
If there's no evidence about a firearms identification card, I would argue that the evidence that's still provided makes it harmless beyond a reasonable doubt, given that in providing evidence that he did not have a license and that he took the vehicle from an unlocked car, that this evidence would be enough for the jury to be able to
infer that he also did not have an FID card? Yes,
Your Honor.
So the defendant says you're not really grappling with the defendant's precise argument here that with the humane practice instruction that the jury could have disregarded the defendant's admission. What do you say to that?
I'm sorry, can you repeat the question?
Well, I think if I understand the defendant's argument correctly, they're basically saying, okay, he's admitted not having this license, right? But that a properly instructed jury could have disregarded his admission and acquitted him, and so therefore we have to remand.
I would say that the jury was properly instructed. If they're referencing the intoxication element, the jury was aware of the evidence of the defendant's intoxication, and therefore that can still go to the jury's weight in determining the credibility of that statement. Additionally, the jury was properly instructed in regards to intoxication, given the difference between general and specific intent, and therefore there was no, the defendant has not proven that there is a substantial risk of a miscarriage of justice.
Okay. Thank you. I'm not sure I said the docket number when I called that case, so just for the record, it's 2024-P235, but the case is under submission. Thank you very much. I think your arguments were very informative for us. Our next case up this morning is 2023-P1481, Commonwealth versus Hunt. And this case is partially impounded, so let's not use the names of the children. or any, reveal any other thing that's impounded, but. I think we'll hear first from Attorney Elliott.
If it please the court, Attorney Edward Elliott, representing Michael Hunt, the appellant. In reading this transcript, I was struck by the trial attorney, I'll call him the trial attorney, even though it was a probation hearing, by the trial attorney's shock and outrage at the about the length of the sentence and which he was primarily concerned about.
So, counsel, I know this is outside the record, but what I remember from the briefing was that there was an appeal to the appellate division of the district court about the sentence. Is that right?
Yes.
And has that concluded?
Unfortunately, yes.
And the outcome was?
No change.
No change. Thank you.
So, but as I began to read the transcript, I began to see why the hearing attorney, the trial attorney, was so upset about the length of the sentence. And although I will get to the substantial legal errors that took place in the case, I think this is one of those cases where there is an injustice. And one of the purposes of the law is to correct injustices. And although there are legal errors in the case which allow for this court to correct that injustice, I think that needs to be something that's taken into consideration. I'm going to start with the non-criminal probation violations. What I consider, I think that the Commonwealth here realized that they had a weak case on the criminal case itself, on the one underlying criminal charge. And so after the arrest, they went forward and they found for what they call technical or non-criminal violations of probation in order to make sure that they would prevail at the probation hearing. And the one that seems to me to be the weakest is the contact that took place after Mr. Hunt was instructed, and he was instructed, not to have any contact with underage children without a legal representative available. But at one point, what happened is that the two men, his partner, his romantic partner, Mr. Kenny and Mr. Hunt, were in a van trying to find a place to exercise their pet, their dog, and they were having trouble finding it. And they were driving around and they saw two girls having a picnic. And they may or may not have pointed at the girls. I would say that pointing at two individuals, I would argue that that's not contact. How the individual...
I knew I forgot to say something this morning. So we have read all the materials very carefully. So the Commonwealth says there's really only two scenarios with this incident. One was that the defendant was the driver and that he pulled up alongside the girls so his partner could ask for directions. And the other scenario, or the defendant was the passenger who directly asked for directions. Do you see any other scenario here?
No, but I don't. But I see that as a critical point, which is the probation order only applied to Mr. Hunt. It did not apply.
Right, but if he was the passenger who asked the question, do you think that would have been a violation of the order?
I don't think it would be a violation of the order because I think it was accidental and unintentional. In the judge's findings, she cites the seminal case Bruno O'Leary, which says that a probation violation is not a probation violation unless it's an intentional and willful one. And I would say that
But if he's the passenger and they drive up next to two minor girls and he asks them a question, how is that not intentional conduct?
Well, it's intentional in that a question was actually asked.
Right, but this is exactly the scenario that all parents warn their children about. A guy, or in this case, two guys in a van. Like, that's the nightmare scenario for parents. Two strangers or a stranger goes in a van, goes up to a child.
Well, I'm not arguing that the girls weren't upset, and I'm also not saying that they didn't do the right thing here, that by calling
I
their parents
understand
and
that.
reporting it. But would that qualify as a willful violation? The court ordered me not to have any contact with underage girls. But I'm going around and I see a couple of strangers and you know, I'm sure he didn't have time to ask them their ages beforehand, and he inadvertently, by mistake, suddenly says, "Do you happen to know where this place is?" And they say no. And what happens after that? Are there any snide remarks? Is there any argument? No. They turn and leave, as any normal person would do.
But then
It was
they come back.
a question to a stranger.
But then they come back.
They turn around, they turn around because they don't know where they're going, but then they leave eventually. And one of the problems I think with the Commonwealth's case is it's a critical question. We don't know who asked the question. There was conflicting evidence in the record who asked the question. If Mr. Hunt did not ask the
Right,
question.
but that's why the Commonwealth says it doesn't actually matter. If he's the passenger and he asks the question, they say that's a violation. But they also say if he was the driver, but he's the one who's in control of the vehicle and he pulls up so that his partner can ask the question, that he's still in control then too.
Well, if he absolutely knows that the people are underage, and the point is only one person could ask the question, and only one person was under a court order.
They were 12 though, right? They weren't 15 and a half.
That's what the record says. That's what the record says.
The Commonwealth argues that the defendant's subsequent guilty plea regarding the assault and battery moots his claim as to the determination of whether the defendant violated his probation. What do you say to that?
I say that's controlled by the case of Commonwealth versus Penna, that a guilty plea does not automatically foreclose contesting a probation violation. I think there were constitutional issues here, especially with regard to the sentencing. The Penna case says that you're not going to foreclose that. That will not be foreclosed if there are constitutional issues. And I think there was a constitutional issue with regard to the sentencing, which is that the Commonwealth brought up an ex post facto law and asked the judge to consider that. And not only did she consider it, it was practically the only thing she considered. She was obsessed by the difference in the ages. And
Well, I don't know why the Commonwealth potentially injected an unforced error, but when he did it, he said it doesn't apply. I mean, that's when he raised this, because he said it was passed later. So maybe it wasn't artful and maybe he shouldn't have done it, but I don't understand how that introduces constitutional error.
Well, it appears from the transcript of the record that the judge relied on that, or could have relied on that, by the fact that this sentence was 4 times longer than was 2 to 3 times longer than the sentencing guidelines. In fact, the judge specifically said, "I'm disregarding the guidelines in this particular case because of the age difference," and that was the actual argument that the assistant district attorney made. So I think there is a definite constitutional issue there. Just returning. I don't mean to go over and over it again, but with regard to the question to the two girls, that was inadvertent and accidental, unintentional. There are many probation cases that say that a probation violation. Here I'm thinking of Commonwealth v. Henry and some of the debt collection cases where Commonwealth v. Canadian, in that particular case, there was a homeless probationer who was surrendered. He couldn't charge his GPS device, So I think that you have to, there's definitely an intentionality component that has to go into a probation violation. And I would also say that in order to prove this particular violation, the Commonwealth relied on unreliable hearsay. The judge, there were objections by the by the trial attorney stating that the hearsay should not have been objected to. He did object to the hearsay. He did object to the hearsay, and the judge in her findings she wrote, I have considered this and I find the hearsay to be reliable. And I would argue there are two instances where the hearsay wasn't reliable. One was where a police officer was able to testify to what the father said about what his daughter said. And then there was the written statement. There was the written statement by the mother, which was a transcription of what her daughter said. And I believe it was actually, it was the same individual and the same individual girl. And she told her father it was the driver who asked the question. And that, by the way, dovetails with what Mr. Kennedy testified to at the trial. He said, I was the driver and I asked the question. And so you have, on the hearsay issue, you have one unreliable hearsay witness saying, oh, it was the passenger, or it was the driver in the case of the father. And then in the mother, the transcription, she says, oh, it was the passenger. Well, that conveniently covers everybody in the van. In other words...
So I just interrupt. I can see why you'd focus on that one violation, but that wasn't the only violation. The judge also found a violation after crediting AG, correct?
After the violation of what?
Crediting the witness AG.
On the contact with the underage children? Or?
Yes.
Yeah. Yeah, I think that...
Well, it was more than just contact.
Yes, yes. In my brief, I did argue that that was a case where, you know, there's no getting around the fact that Mr. Hunt signed probationary conditions saying that he was not supposed to have contact with, unsupervised contact with children under the age of 16. That, I mean, I have to admit that that was a probationary condition. But
I'm referring to the sexual assault on AG.
Oh, yes. Well, my argument, the argument there is...
Your argument was that he wasn't credible, correct?
Right.
But isn't that a determination for the judge to make who hears the evidence and evaluates AG?
It is, but the evidence here, his various statements to various witnesses were so contradictory that I think that I would argue that this was a case where the appeals court should step in and say that the assessment shouldn't have been made, that the judge made the wrong factual assessment. Because I think he...
So on this record, we're going to substitute our judgment, our assessment for the trial judges.
I honestly think that that actually would be appropriate because the witness, he said, his first story to his first, first complaint witness was, oh, Mr. Kenny and Mr. Hunt were in the basement together and they were offering us money. And then he told somebody else, oh, Mr. Hunt just touched my thigh. Then he told a different story to somebody else. So there are so many contradictions in his story over the years that I don't think his evidence was actually credible. But I did want to touch on just one point with regard to those other three non-criminal probation violations, and those being that for 8 years, Mr. Hunt was on probation, meeting with his probation officer. At any time, that probation officer could have said, you know, I think this is a dangerous situation. I don't think you should be renting to families with children. He never did that. In fact, there was a case in which somebody complained and said, these people are renting to families with children. And he didn't write it up as a violation. So what kind of guidance does that give to Mr. Hunt in terms of other possible momentary short interactions?
I understand your point that maybe it was not well advised for them to be renting the other apartments to children, but why does that inherently mean that he would be with the children unsupervised?
Because if a probationary condition is not enforced by the person who's supposed to enforce it, which would be, in this case, obviously the probation officer, it leads a person of reasonable intelligence to wonder whether it's still in effect, or whether his actions are in compliance.
But nobody said to him, you can be alone with children, right?
No, that, I will concede that. And as I would say, these are momentary, at least in the
Yeah,
record, momentary
I
non-criminal
think
violations.
I'm going to check to see if we have any other questions, but you're at your time. Good. Okay, so we'll have to leave it there, and we'll hear from the Commonwealth. Thank you.
Thank you. Good morning. May it please the court. Andrew Covington for the Commonwealth. I was also the trial attorney on the underlying final violation of probation hearing. The Commonwealth respectfully requests that this honorable court affirm the trial court's order revoking the defendant's probation for the following 4 reasons. First, there was sufficient evidence to support 4 violations of probation after the Commonwealth established by a preponderance of evidence standard that the defendant violated his probation in 4 different ways. Number 2, the trial judge properly declined to recuse herself after considering the defendant's motion and applying the test outlined in the Lena case. 3, the judge properly imposed the sentence. The sentence was well within the statutory bounds. 4, the sentence was in no way cruel and unusual. It was well within the statutory bounds. If I could start with the sufficiency of evidence argument, the problem with the defendant now raising issues relating to probation violations number 1 and number 2 involving AG is that issue is moot because the defendant, about a month after the violation.
So he pled, I understand, but he's arguing that under Commonwealth versus Pena, that it's not moot. So what's your response to that?
I believe the defendant is misinterpreting not only the Pena case, but also the Milo case, the 2 cases that the Commonwealth cited. So the sufficiency of evidence argument is moot, and whether or not hearsay was admitted is moot. However, the defendant, those cases stand for, the defendant is free to make constitutional claims. He's free to make an argument that the judge should have recused herself. We don't agree with that argument at all, or that the sentence is cruel and unusual. So the defense is not prohibited from.
Are you saying it's moot, sufficiency is moot on all 4 violations, or just the 2 involving AG?
Just the 2 involving AG, Your
Okay.
Honor. Yes.
All right, thank you.
So
not the Oakham.
Not the Oakham matter, yes.
So
Yes, Your Honor.
on the Oakham, is he correct when he says that the father said, the girl said it was the driver who asked the question?
If you look at the record, Your Honor, yes. Through the hearsay of Sergeant Tucker, who testified, and Judge Mulqueen allowed that hearsay to come in, Sergeant Tucker believed that the father said that it was the driver who asked for the question. However, when you look at the written statement that was authored by the victim, by the child, through her mother, it's clear in the statement that the child indicated that it was the passenger who asked for directions. So there was some.
And do you consider that written transcript, or the thing that was written by the mother, is that really a statement of the child because she was dictating it to the mother?
Absolutely correct. I think that's clear in the record and clear from the way the officer testified that the 12-year-old was in such distress, was so upset over the incident that took place that her mother wrote the dictation in the police station with her daughter right there next to her. And it's clear in that statement, according to the child, that it was the passenger who asked for directions. And if you look at Mr. Kenny, who was the defendant's partner at the time, he testified that he was the driver. So taking that together, the Commonwealth goes back to our first point. I think the evidence suggests that the defendant, Mr. Hunt, was the passenger who asked for direction. But in either scenario, the defendant clearly violated this specific order that was issued out of the Eastern Hampshire District Court.
So what about the argument that that Attorney Elliott was making at the end, which was that here's this guy who's not supposed to have unsupervised contact with children, and yet he lives, I think, in a 3-family, and they're renting 2 other apartments to people who have children. And that the probation officer knew that was happening.
I don't believe that there's any record at all that there's any evidence that the defendant violated his probation, Your Honor. I do believe it came out during the hearing that the probation officer was aware that he was renting, so the defendant was living on the third floor with his partner, Mr. Kenny, and then he was renting out the second and first floor to other tenants. I believe P.O. McDonald testified that he was aware, was brought to his attention that some family members with kids were renting out floor 1 and 2. But to my knowledge, there was no allegations or ever any references that the defendant had violated his probation, meaning having no unsupervised contact with children, and for whatever reason, the probation department did not bring that forward. That was not alleged at all, to my memory, Your Honor.
So if the defendant was a passenger in the van and the driver drove up to some girls and the driver asked a question, would that be a violation for the defendant?
I believe so, Your Honor, because again, there's two different interactions.
Even though he's not in control of the van?
Well, the issue is, Your Honor, is that there was 2 contacts 15 minutes apart, so.
No, I'm asking you a hypothetical question. If the defendant was a passenger in the van and the van drove up to 2 12-year-olds, let's make it even easier, 10-year-olds, like clearly minors, and the driver of the van asks a question, the defendant's the passenger, he just sits there, is that a violation of his probation?
I would say probably no in that situation. That'd be incidental contact. I think the difference here is, Your Honor, is the testimony and the evidence that the 2 waved at the girls 15 minutes prior and then had approached the van. But again, the Commonwealth believes that the evidence supports that the defendant was the passenger and was the one who asked for directions. So in your hypothetical, Your Honor, no, I don't believe that would be a violation of probation, but I think the 15-minute interaction that they had prior, I think adds to the criminal effect here for sure.
What's your understanding of what authority we have to review the sentence imposed here? I know it's very limited, but I'm just, how would you phrase the standard for us?
I believe it has to shock the conscience, Your Honor. It's really a high standard. I'm not aware of any case, and the defendant doesn't cite any case beside juvenile homicide cases that have been sent back with parole issues where a review in court has found a sentence that's within the pertinent statute, like this is, to be sent back to a trial judge to resentence them. I'm not aware of any cases, nor has the defense cited any cases, but rape of a child is a statute that carries life in prison. Even back in 2001, it was a life felony. It's still a life felony today. And to just briefly touch on the defendant's argument that I made an argument asking Judge Mulqueen to apply the new law, aggravated rape, to the conduct that Mr. Hunt committed in 2001, is not accurate. In this case, the Commonwealth and the defense had about a week to prepare sentencing arguments. We both, as the court could see, submitted memorandums for sentencing. There was a lengthy argument on both sides. The defense in this case, during sentencing, as well as on appeal, has really minimized the conduct that the defendant pled guilty to in 2001, described the rape charge as consensual between the defendant and a child. I was simply highlighting to the court that when one looks at 265 section 23, which is your statutory rape charge, which many people think to be a 20-year-old and a 15-year-old or a 21-year-old and a 14-year-old. The age difference was very vast. This was a 28-year-old and a 14-year-old. And the defense was asking to apply the guidelines for rape of a child nowadays, which is 40 to 60 months, which I was simply highlighting to the court that the conduct that the defendant pled guilty to in 2001 involving a 14-year-old was not a typical statutory rape charge, which is why the Commonwealth believed that the sentencing guidelines were inappropriate and should be much higher.
He's saying by citing this law that didn't exist at the time, you've injected an error. We don't know what the judge was thinking, or did that misdirect to the judge in terms of the sentence? So what do you say to that?
I would say no, and kind of going into the recusal argument that the defense made, that this judge is very experienced. She's been a Superior Court judge for 5 years. She had previous experience with child abuse cases. She didn't apply the minimum mandatory in this case. The minimum mandatory nowadays for the actions that the defendant committed would be 10 years. That would be the minimum mandatory. She did not sentence the defendant to a 10-year or more sentence. He was given a 9 to 11-year sentence. There's nothing in the record indicating that Judge Mulqueen believed that I was making an argument to have her apply the new law to the old conduct. Contrary, I believe Judge Mulqueen was very clear that she was extremely concerned that the defendant was on probation for rape of a child involving a 14-year-old boy when he was 28 years old. The defendant was on probation for sexually assaulting 3 different minors. He was then found in violation of probation for having sexually assaulted another minor and having prohibited contact with a total of 6 children. So I think Judge Mulqueen was very clear. I didn't ask, the defense didn't object when I made that statement, and there's no information in the record that the new law, aggravated rape, was applied to the conduct that Mr. Hunt pleaded guilty to in 2001.
So the defendant argues that the judge may have based the sentence on uncharged conduct. What do you say to that?
I don't see that at all, Your Honor. I don't believe there was any uncharged conduct at all. The Commonwealth, with the probation department, proceeded with and presented a very clear case. This was not a case where the Commonwealth was submitting police reports or grand jury minutes or multiple levels of hearsay. The Commonwealth called direct eyewitnesses victims to the charges. I'm not aware of any past misconduct that we were asking the court to punish the defendant for. I was very clear what the defendant was on probation for, the conduct that he was on probation for, and the Commonwealth went forward with 4 very specific allegations of violations of probation to the point where I even filed a bill of particulars in this matter, which is also evident in the Commonwealth's brief as well. I'm not aware of any outside conduct or any punishment not relevant to this case that the court punished the defendant for.
When the defendant was originally sentenced, I'm not talking about on the probation violations, I'm talking about on the underlying offenses, what was the maximum sentence that he was given?
6 to 8 years in prison, Your Honor. So it was a bit complicated. The defendant was arrested in Franklin County, which is our county under the Northwestern District. The investigation led to the defendant had committed sexual acts towards minors in Worcester County. So there were 2 cases taking place at the same time back in the early 2000s. There was two dockets out of Franklin County and 2 dockets out of Worcester County. And they were wrapped up in a global disposition where the defendant essentially received a 6 to 8 year state prison sentence followed by 15 years of probation. However, the court should know that the defendant was committed under the sexually dangerous person statute for about 5 years. So he was released in 2014 and placed on probation then. So his probation was supposed to go, I think, until about November of 2024. But it was a 6 to 8 year state prison sentence, Your Honor.
And so then for this, he gets 9 to 11 then is imposed?
Yes. And I would argue that the court agreed with the Commonwealth's position, as I mentioned, that the court was very concerned that, 1, the defendant was on probation for sexually assaulting 3 different minors, and he reoffended sexually with a minor and also had prohibited conduct with 6 children. So probation wasn't working, the STP commitment wasn't working, and clearly the 6 to 8 year state prison sentence that he was given in the early 2000s was not working as well, Your Honor. Again, the defendant could have been sentenced to life in prison. As I mentioned in my brief, there is a case where the appeals court has even said where the court sentenced a defendant to life in prison, that was not cruel and unusual because it's within the statute, within the pertinent bounds of the statute, Your Honor. If I could just briefly touch on the issue of the trial judge properly declined to recuse herself. The Commonwealth was shocked when trial counsel filed a motion for the trial judge to recuse herself. The motion was based largely in part that prior to 2018, the trial judge had been a prosecutor in Hampden County and the Northwestern County, predominantly doing child abuse cases. I would highlight that the Commonwealth didn't take a position on that motion. The court properly applied the 2-pronged test in Lena, consulted with her own emotions and believed that she could properly hear the case. She then went to step 2 and objectively believed that the outside would not challenge her ability to hear this case. So, and also, if we were to follow the defendant's logic in this case, really any trial judge with prior medical malpractice experience or prior drug experience or homicide experience would have to recuse herself. It's just unreasonable, and it's just not what the factors ask for in the Lena case.
I mean, how long had the judge been on the bench, or how long it had passed between the time she left the DA's office in this case?
5 years, she indicated.
5
She
years.
did indicate that during the Lena analysis, Your Honor.
So you say it'd be unreasonable, but let's say it was the day after. Let's say she was in the district attorney's office on a Friday and then she was on the bench on a Monday. And I remember the public walked in and saw she was presiding over a rape trial, and they said, wow, she was just ahead of the sexual assault unit in the DA's office, and now she's presiding on a rape trial. I wonder if that's fair. Would there be concern on the second prong of Lena in that instance?
Perhaps if the trial judge was presiding over a case in the same office that judge was at, that could potentially be a problem, because that judge may have been in the office, probably was in the office when the case came in, and that judge may even have a memory of the case coming in.
The subject matter, you don't think?
I don't believe so. I just think judges are vetted, they're well vetted, and they go through a stringent process, and for them right away to recuse themselves from certain cases because they heard those cases in the past, I don't think that's the standard in Lena, Your Honor. But I think if it was the same office, likely. I don't think the judge would put themselves in that situation. If I could just finish with this, we're talking about a preponderance of evidence standard, more likely than not beyond a reasonable doubt. And the court would have to find that the trial judge abused her discretion. She did not. Pending any questions, I will rest on my brief. Thank you.
Thank you very much.
Thank you, Your Honors. Thank you.
Well argued by both sides. We'll hear our third case this morning, 2021-P-0879, Commonwealth versus WILFREDO Lopez. We'll hear first, I believe, from Attorney Warren.
Good morning, and may it please the court. John Warren on behalf of WILFREDO Lopez. There are two overarching problems in this case. First, this is a trial that boiled down to the credibility of the alleged victim, and Mr. Lopez was not afforded a full and effective cross-examination of her during the trial. Second, aside from the alleged victim's testimony, the only purported corroborating evidence was this nebulous statement by Mr. Lopez that trickled in through the mother and then through impeachment of the mother by the DCF worker. And that statement should not have been admitted because the mother shouldn't have been permitted to testify, where she was only called for impeachment purposes. And the problem was made worse where the Commonwealth misconstrued the mother's testimony in closing argument. And if I could, I'd like to start there with the Commonwealth's closing argument about what the mother testified to. So on transcript 3, page 146, the Commonwealth in closing stated that her, meaning the mother's, testimony on direct examination was that the defendant did admit to touching the alleged victim. She told you that they must have been playing around, but that he touched her breast. That's the Commonwealth's closing. And when you look at the mother's testimony, I would suggest the most clear answer she gives is when she's asked directly by the Commonwealth on direct examination. And he indicated that he touched her in the breast area by accident when they were playing around? No, the mother answered. No, the Commonwealth asked? No. And so where you have clear...
But she kind of goes back and forth on this, right? I mean, there's inconsistent testimony with that as well.
Well, what I would suggest is when you look at it as a whole, the only fair reading of her testimony is that she denied that story, that the statement was that the breast was touched while playing around. I think that what I just read to the court, it really can't get much clearer than that. She's saying that was not what he said. Later on,
you can get less clear than that, though, right? With her other testimony makes it less clear, right? And that's the problem for your position.
I think it gets confusing based on the way the Commonwealth is asking questions later on, because the Commonwealth says, so when he said he may have touched her, what was he referring to? And the mother answers, well, when she said that he touched her boob, so that's why I confronted him. So the mother's answering a question about what he said by saying, this is what she said. Then the Commonwealth says, so it was her breast that he was talking about, which there wasn't evidence. This was direct examination. This is a leading question of evidence that hadn't been introduced, and the mother answers yes. But I think when you fairly look at that, and when you consider that in light of the direct testimony, which is inopposite to that point, the conclusion needs to be that the mother was denying that he touched her breast even while playing around. And for the Commonwealth to get up in closing and say the opposite, that is what she said, regarding a key issue in the case, which is the only corroboration of the alleged victim's testimony, that's really a problem, and it's not something the jury could have sorted out on their own. And
I'm not sure your conclusion is the most reasonable or accurate, but it is fair to say, I would allow that no reading of her testimony would support an inference that he touched her with criminal intent, correct?
Correct. Correct. And I think when you go further on to the Commonwealth's closing, where they argue, if Samira was if the alleged victim was lying, why did the defendant apologize to her? Why did he tell his wife that he did touch her breast? And so again, I think that is distorting what the mother's testimony was on a key point, because again, this is a case that boiled down to the alleged victim's credibility. The only piece of evidence that sort of corroborated that was the testimony of this testimony of the defendant's statement.
And this is unobjected to during questioning of the mother and also during closing argument. So we're reviewing for substantial risk, correct?
Exactly, yes, Your Honor.
And, well, I'm sorry.
And so turning to whether the mother should have been called at all, which is issue number 2 in my brief, this is the McAfee and Maldonado rule, which states that a party cannot call their witness just to impeach that witness. And I think more precisely is the U.S. versus Hogan case I cite in my brief, which is, it poses the question, was the primary purpose of calling this witness to impeach them? And what I would suggest when this court looks at the 6 pages of transcript of the mother's direct examination, that this court should come to the conclusion that what the reason this mother was called was simply to get out her confrontation of Mr. Lopez, and then to call the DCF worker to have that statement impeached.
So do you think the mother's testimony that the defendant said that if he touched the child, it was an accident, do you think that was helpful to the prosecution?
I don't think it was helpful to the prosecution. I think what preceded that was the mother being directly asked, did he admit to doing this? And she says no. And that's the very testimony that the Commonwealth sought to impeach through the DCF worker, Ms. Lamalino. And so I think where the only potentially probative testimony is the very testimony that the Commonwealth chooses to impeach, then you have a violation of this McAfee-Maldonado rule. Everything else that the mother testified to on direct examination was background testimony about her children's ages, where she lived, how she knew Mr. Lopez. It wasn't probative, and it didn't go to whether Mr. Lopez committed this offense. And I think it mirrors the sort of background questioning that you see in the Benoit case, where there's...
So just so I understand your argument, your position is they wouldn't be able to call the DCF worker but for calling the mother. And so therefore, the mother wouldn't have testified in the DCF, so there would have been no evidence about any potential incriminating statement from the mother other than this kind of two-step process. Is that right?
That's right, exactly right.
There wouldn't be any basis to call the DCF worker directly.
Exactly, because the only reason the Commonwealth called the DCF worker was to offer that impeachment of the mother,
right.
Which again was the only reason they called the mother.
I mean, the Commonwealth says, well, you know, she had testimony about the family and household arrangements and confronting the defendant about the victim's allegation. That was all kind of relevant evidence.
So to break that down, I think the first part of that, just the background, that's not really probative evidence. It doesn't go to show whether it's more likely or not that Mr. Lopez committed this offense. Yeah. And so that's exactly the sort of background questioning that the Benoit case talks about. Turning to confronting him, I think independently, that's inadmissible evidence that the mother confronted Mr. Lopez about an allegation. On its own, that wouldn't have been admissible. What was purportedly admissible was his response to it. But that was the very statement that the Commonwealth sought to elicit so that they could call the DCF worker to impeach it.
But if the Commonwealth thought that the mother had a statement that was damaging to the defendant, which I think there's a good faith basis they did based on the record, why would they not be able to call that witness thinking she may testify to that statement?
Well,
Are you suggesting that they knew she was going to deny or deny what he said initially, what she reported?
Right. I think, Your Honor, if when you look at the transcript, and the defense raised this prior to the mother testifying at page 68 and 69, and then during direct examination of her at page 106 to 107. But the defense raised this to the court ahead of time. And I think when you look at the way it was argued, the fact that the Commonwealth had said, we have this DCF worker here because we know that Mr. Lopez and his wife are on good terms, we have this DCF worker here for impeachment purposes. I think the reading of the transcript is people knew where this was headed and that she was going to deny what she had purportedly told the DCF worker.
So if the question is, did the Commonwealth have a good faith basis to call her, and they know from the DCF worker that they believe the mother said this incriminating statement, even if they're not sure if the mother's actually going to do it or not, isn't the fact that they know it from the DCF worker a sufficient base to call the mother as a witness and see what she says? That's kind of, I'm trying to process what the implications of your argument.
So I think when you look at how it was argued that people, the parties appeared aware that she was going to deny having made the statement. And when defense counsel raised the issue under Maldonado, that the judge at that point should have precluded her from testifying. But even if that wasn't the right answer, when she gets up on the stand and she's asked, did he admit this to you? And she denies it. At that point, the defense does object, and that should have been sustained because at that point, it was patently clear that she was going to continue denial as she got more specific with her statements. And so when they got to ask that precise statement that they later sought to impeach through DCF, we would have never gotten to that point, essentially. If I may turn to the issues on cross-examination, this is, and specifically this is issue number 1 in my brief, but I went through several areas where Mr. Lopez's attorney tried to get into areas of cross-examination and he wasn't able to do it. There was the limiting evidence of the alleged victim's trouble to school at one day, but I think most importantly is the 2 close-in-time allegations of sexual assault with respect to third parties. And what I would suggest is this is a case that came down to the alleged victim's credibility, and the defense here was there's a teenager who's getting in trouble at school and that she made up these allegations to essentially deflect blame of her own troublemaking. And what the records from DCF showed is that the alleged victim had made 2 subsequent allegations of sexual assault. One of them was a month after the allegation of Mr. Lopez, where she's at the program and she alleges, she makes an allegation of sexual assault in the context of someone walking in the room during a sexual activity. And then 18 months later, where she's ran away from the program and came back and made another startling allegation. So we have, in the span of 18 months...
What's the basis for that either one of those allegations was false?
So with respect to the March 2018 allegation, which was a month after the allegation against Mr. Lopez, the alleged victim initially denied that it happened. So there's a report to the program speaks to her about it. She first denies that it happened.
Right, and then she sends a text that indicates she wants to engage in the activity, but not at the program, somewhere else.
Exactly, Your Honor. And I think when we have her denial, when we have the lack of apparently a sane interview or charges being filed, which by themselves I don't think would be enough, but then you layer on top of it this text message she sent to this individual indicating that she wants to engage in this sexual conduct, that's enough. That's enough.
Well, to parse that out a bit, she initially denied. It's difficult to tell from the report, but a reasonable inference is she denied when initially being asked, but then soon thereafter, during the same conversation, told them a story in which she was sexually assaulted. Do you agree with that?
I agree with that.
And it's unclear when these, were they Snapchat, or what was the message between allegedly the minor and the other minor? What was the communication? What, Instagram, Snapchat, what was
Yeah,
it?
right, Snapchat. It was a Snapchat.
It's unclear if that was before or after, correct? The timing really isn't clear to me.
My reading of it was that it was before, but that could be because it's the alleged perpetrator coming forward with it, saying, look, I have this Snapchat message. But from my memory, I don't know if the timing was pinpoint as to when that was sent.
Either way, that's not a recantation, correct? There's no way you can look at that as a recantation.
It's not a recantation, Your Honor, but I think to fairly look at it, the question is, I think, was this a consensual encounter? And we have evidence that this is something she wants to do because she sent that text message. Hey, let's run away from the program. Let's engage in the sexual act. Then she's later saying it was forced upon her. And I think when you look at it all together, and then in the context of the October 2019 incident, and look, this is very uncomfortable, right? We're dealing with an alleged victim making these allegations. But we're also dealing with Mr. Lopez's liberty and giving the jury the full picture of what's going on here. And, I get it. It's a teenager and these allegations she's making. But what I would suggest to the court is that Mr. Lopez's constitutional rights required that the jury hear the full picture, hear the allegations that she was making, and that's wrapped up into Mr. Lopez's rights to confront this witness at trial.
So I have a question here at a time, and I'll check and see if anybody else has a question. But you raised the prospect in your brief of us remanding for a determination of whether there was ineffective assistance of counsel. Why can't the defendant just move for a new trial on that basis?
Your Honor, I don't think there's any reason precluding the defendant from doing that, as to that fourth issue I raised in my brief.
All right, we'll hear from the Commonwealth.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court, Tracy Cusick on behalf of the Commonwealth. Your Honors, the Commonwealth is asking this Court to affirm the defendant's 2 convictions for indecent assault and battery on a child under 14. And, Your Honor, I'll start with the closing argument issue first and the calling of the mother. I would suggest first there was a good faith basis to call the mother as a witness. One can infer from the record, I'm not sure it's entirely clear, but that the mother did report to DCF that she had a discussion, for want of a better word, with the defendant about the allegations, and he had made statements to her about those. I suggest that is a good faith basis, among other reasons, to call the mother to testify about what that statement was. Here, the Commonwealth did file a motion relevant to the marital privilege. It's unclear what prompted that, but certainly the mother and the defendant were married at the time of the incident and at all times relevant. So one can infer from that there was certainly a concern that the mother was going to invoke a marital privilege and perhaps seek not to testify. So certainly I suggest there was ample reason for the Commonwealth to not be entirely confident that the mother was going to testify in accordance with what she had said to the DCF worker previously. But the fact that the Commonwealth may have suspected that she was going to perhaps differ in her testimony doesn't make it a bad faith purpose in calling her to testify. So I suggest there was nothing amiss in the Commonwealth's decision to call a witness to whom the defendant had made statements about.
So just you can have a good faith basis to call a witness, even if you suspect that the witness is actually not going to provide the statement you want at trial based on her an alleged earlier statement that she made to a third party. Is that what you're saying?
Yes, Your Honor. That certainly, I mean, here there was ample evidence that she had said the defendant reported something about what had happened to her, and that was memorialized in the DCF report. So I suggest that there was nothing amiss with calling the mother to testify, and certainly the Commonwealth was candid that they called the DCF worker because it's possible the mother says something different. You never really know until the person testifies exactly what they're going to say.
Right, so he argues, though, once the mother said, no, he didn't say this to me, that the next questions were without a good faith basis. So what do you say to that?
Your Honor, I would disagree with that. I would think the questioning was a little perhaps inartful, but looking at the transcript at page 106, the question was, did you speak to him about those allegations? I did. Did he admit those allegations to you? He did not. What did he say about those allegations? I suggest that that's a perfectly appropriate question. What did he say? And then the mother's response was, I suggest the proper reading of this is that his response was, well, I didn't, but if I did, it was an accident. I suggest that that's how this response can be interpreted. He denied the allegations, but then he also said, but if it did happen, if I did touch her, it was an accident. We were just goofing around. That's what happened. And so I suggest that there's nothing wrong with this line of questioning.
No, that's not the point, though. It's after that, right, where he says, then you know what you have a basis to expect what her testimony would be, and you go into, well, didn't you tell DCF something else? Not you particularly, but the Commonwealth. And he's saying that's the part where the line was crossed.
I suggest the question was, during the conversation with DCF, this is on page 108, you didn't tell the DCF worker that it was by accident and they were playing. And the mother says, no, I did. So I suggest here it's not, once the mother said, no, we didn't admit it to me, I don't believe that that had to be the end of all questioning, that it was perfectly appropriate to probe further. And here again, it was a very brief discussion on direct examination with the mother, but then on the defendant's cross of the mother, counsel, I suggest, heard it the same way as I'm suggesting it was, would have been heard by the jury. On page 113, defense counsel says, and correct me if I'm wrong, essentially, well, if I did touch her, it was sort of an accident. So I suggest that that was the explanation, that was what the mother's testimony was, that was before the jury. It was perfectly appropriate to elicit that testimony, and it was appropriate to elicit that she had said something else to the DCF worker when she spoke to the DCF worker.
Was it appropriate the way the prosecutor summarized it in the closing argument?
Your Honor, reading through it, it is inartful, it is not verbatim, it perhaps could have been better phrased.
I mean, the problem seems to be that the prosecutor indicates that it was said with intentionality, right? If E.B. is lying, why did the defendant tell his wife that he did touch her breast, right? When in fact, the best evidence for you that you have is that if he touched her for any reason, it was by mistake, right? So the prosecutor's bringing in some sort of notion of intentional touching when the evidence doesn't really support that, even in the best light to the Commonwealth. Because that seems to be the problem.
I think I agree, Your Honor, it may have been better phrased, but I'd suggest here there was no objection. I'd suggest there's no substantial risk here because, again, the jury would have heard that testimony. The mother's testimony was, you know, if he told me if it did happen, it was an accident. They were instructed on accident by the judge. And I would suggest there's no substantial risk here of a miscarriage of justice based on the closing argument.
Usually we see an instruction during the final charge about closing arguments not being evidence, but oddly, there was not one in this trial.
Your Honor, at the beginning of the trial, I agree, I looked for it in the final charge and I didn't find it, but at the beginning of the trial, there was a pre-charge where the judge did inform the jury what the closings were not evidence, and it was a one-day trial. The jury did come back a second day to deliberate, but they heard the pre-charge, the evidence, the closings, the final charge, and began deliberations all in the period of one day. So they were instructed at one point about what a closing argument is, but I agree, it would have been preferable for it to have been in the final charge.
I mean, looking just at the statement that the mother's, in the closing, that the mother's testimony on direct examination was that the defendant did admit to touching the child. That's an overstatement, right?
That's not exactly what the mother said during her testimony. I agree. That is, it goes a bit further than what the mother said.
Okay.
Your Honor, if I could move on to address some of the other issues that were raised with respect to the other allegations of sexual assault that the victim made, I'd suggest that those were properly excluded. I suggest that
What's the threshold that the defendant has to meet for one of those allegations to be admissible?
Well, Your Honor, I guess it's for the threshold for them to be admitted, certainly for the rape shield statute, some indication that this was false, and I suggest...
But he's saying this is, the rape shield statute doesn't apply because this isn't sexual activity. This is about another allegation of rape, essentially. Is he right about that?
Your Honor, being raped is also sexual activity. I believe the case law states that explicitly, that if somebody has been raped before, that counts under the rape shield statute, that you don't just get to say, tell us about the last time this happened to you. I suggest that the rape shield statute does apply to allegations of being sexually assaulted.
So he says, well, there's a text message where the child says to the other child in the transitional living, let's get out of here and engage in this sexual activity, right? And then she is alleging that he forced that in specific sexual activity on her. So he's saying, well, that's some evidence that it was false. What do you say to that?
Well, Your Honor, I say to that, if you look at the report, it's not very clear exactly what that is. It seems to be that the person who was accused of the sexual assault offered up a Snapchat or some sort of communication. It's not exactly clear, was that confirmed to have been authored by the victim in that case? What was the timing of it?
Right,
if she
but
had
I
a
guess
group.
the question really I'm raising, and I've written on this in another case, which is, you know, this is not a situation where the defendant is in control of the evidence, right? Because he's not in control, the victim, he doesn't have any, you know, ability to just ask the victim anything he wants. He doesn't necessarily have the ability to take discovery of some of this specific other incident. And yet the burden is on him to show it's false. So here he's come forward with something that, you know, I mean, I know the tea analogy, right? I can ask for a cup of tea today, and then I could turn around immediately as soon as you pour it for me, and I can say, I don't want the tea, right? So, but he said, okay, here the victim has said, let's go have tea. And so is that anything, or is that nothing?
I don't think that helps the defense, because, again, even in a light most favorable, I guess, to the defense, if somebody makes arrangements for somebody to go off and have consensual sexual activity, that doesn't mean they've consented to anything that might happen thereafter, and they can't report that they've been sexually assaulted and that they can't be, that their allegation can't be found credible. Just because they at one point consented to sexual activity doesn't mean they've done so for all time. But also suggests that these allegations are strikingly dissimilar than the allegations involving this defendant. These allegations involve teenage peers in a program.
Right, but he's saying that, that the allegation is that she was in trouble And the next thing that happens is she makes a sexual assault allegation, and that happened now, with the one peer, and then it happened with the other peer.
Your Honor, I suggest that that's not my reading of the records. And again, Your Honor has the records, and the court can read them and see what it says. But one of them, the young people return to the program, and then there's the report of the sexual assault is made after they've reported to the program after having eloped for some hours. There's nothing in there saying that they were in some sort of trouble. They had left. They weren't supposed to, but it wasn't in there that there was some real bad trouble afoot, and that it was something that she
In
would...
trouble for, shouldn't they get in trouble for leaving a program unauthorized?
Your Honor, I'm not sure exactly what happens to somebody that leaves a program without authorization, but it does appear that they returned voluntarily to the program.
Good, yeah.
But again, I would suggest, one could find, I would suspect in any scenario, that a person must have alleged sexual assault because there was some trouble of some nature that they're trying to avoid. And I would suggest that that's not the rule under the Rape Shield statute, and it shouldn't be permitted. And again, here, it's very dissimilar, the types of, the nature of the allegations with these young boys in these cases. And again, the defendant was an adult authority figure household member. And I'd suggest it's very dissimilar. The Jake's or Jack's case, I'm not sure how that's pronounced, I suggest also stands for the proposition that they have to be very similar type allegations, and these are not. And I would suggest that the judge properly declined to allow those into evidence.
On the issue about the cell phone report, had the Commonwealth indicated why it was considering calling Detective Williams?
I'm sorry, Your Honor?
On the issue of the cell phone extraction, had the Commonwealth indicated to the defendant why it was considering calling Detective Williams?
I'm not aware of the answer to that, Your Honor. I don't know.
Well, the defendant is basically saying that the Commonwealth sort of led him down the garden path, thinking that Williams could put the cell phone report in, and the defendant, I don't want to say fell for the head fake, but I'm not saying it was intentional on the part of the Commonwealth, but the defendant thought that the Commonwealth was planning to use Williams to get this report in, and then when the Commonwealth didn't use him, the defendant said, well, I'm going to use him, and then got the rug pulled out from under him.
Well, I disagree with that characterization, Your Honor, but I suggest here, I think Williams may have been on a witness list. I can't recall exactly, but I believe the Commonwealth had indicated its witnesses was going to be the victim, the mother, and the DCF worker. And certainly, I believe that was at the very least a few days before trial, and I would suggest that it's certainly incumbent on the defendant to do the homework and figure out who the witnesses are if you want to get a piece of evidence in. So I would suggest that certainly the Commonwealth didn't do anything wrong here, and if the defendant believes it's something that is ineffective, then the defendant could bring a motion for new trial. I suspect there might be cross-examination of whoever did the cell phone extraction that might shed more light on the significance of the apparent absence of text messages in the extraction report.
All right, I see that your time is up. It's well argued on both sides, and I think we understand your positions. The case is submitted. We'll take our mid-morning break now for about 15 minutes, and we will resume with the final 3 cases for today. Thank you very much.
Thank you.
All rise. We'll stand at recess. session. Please be seated.
Morning again still. We'll have our final 3 cases of the morning. In case people weren't here earlier, we have read all of your materials. We're quite familiar with them. It's 15 minutes per side with no rebuttal. And the next case we're calling is 2024 P157, Tatuli versus Avalonbay Communities.
If it pleases the court. Good morning, Your Honors. I'm Walter Jacobs for Margaret Tatuli. This case concerns the denial of a motion for class certification regarding issues related to a tenant's security deposit. The trial judge denied the motion on the grounds that the issues were not conducive to the class as a whole.
The motion judge.
At the documents.
I'm sorry, the motion judge, Judge Henry.
Motion judge, yes.
And for the record, that is Bruce Henry, and there's no relation.
No relation. But it was a different judge than the judge who ruled for you on the merits. Is that right?
That is correct.
Thanks.
Counsel, speaking of that, having received a judgment on the merits, do you have standing?
Pardon me, Your Honor?
Does your client have standing? Your client received a judgment on the merits in this case.
I believe my client does have standing, Your Honor, because we received judgment on the merits, but we were denied the ability to act on behalf of the class as a whole. The only way that she can do that, since that was an interlocutory ruling of Judge Henry, is to file an appeal.
Do you have a case in that posture where the judge denied class certification, a substantive judgment entered for the one potential named plaintiff, and then the appeals court or the SJC said, oh, there should have been allowed or more on class discovery and let it go back?
I cannot give you a specific citation to that specific issue, but I think that there's the only way that Mr. Tuli would be able to represent the interests of the class, and I believe this case resolves around class interests, would be to file an appeal. Once the judge made his decision with regard to the motion to class certify, there is no other option other than to proceed in the case as an individual case.
Well, could you have filed either a petition to the single justice or something else to seek interlocutory review?
One might have been able to do that, but given that the courts prefer that the case be dealt with on appeal, we didn't know at the time that that decision was made whether we would prevail or not. We certainly would have to prevail on our issues to be able to be representative of a class.
I think the concern, though, is are you asking, or would the judgment in favor of your client need to be vacated for her to be able to be a class representative? Or at this point, is she out because she won?
I don't know that the judgment in her favor necessarily has to be vacated. I think she has the right and still would have the right to represent a class because she has demonstrated that she has definite validity to her allegations. The only question would be, does she represent a class? Do the facts of this case suggest that she was similarly situated as to other members, which would be the same position she'd be in the case as a whole?
What remedy would she be seeking herself?
Should be seeking the right to represent the class, to go forward to represent the interests of the class. As the trial judge emphasized in his final memorandum and decision, she did accomplish a good result as far as making sure that the landlord understood he could not do what he was doing. He was violating Chapter 18615B in multiple ways, but the other members of the class did not have an opportunity to be represented at all. Mr. Tuli was trying to do that not only for herself, but for the class as a whole. And the issues that revolve around the class are looking at the documents that Avalonbay uses. The move-in...
Go ahead, go finish your thought.
The move-in, move-out sheet, the preliminary move-out, and then the notice of preliminary inspection. All of those are pre-printed forms. Those talk about cleaning charges, small amounts of painting charges, things that would not be covered under the damage clause of a security deposit. So it's nothing that is just unique to Mr. Tuli.
So these are, your position is that these are policies of Avalonbay, and therefore this is a kind of structural problem that's appropriate for class certification, right?
Routine.
Yeah, go ahead.
Yes, sir, I apologize. Routine and clearly routine practices of Avalonbay as shown by their pre-printed forms.
Okay, let's assume that your request for class certification isn't moot. You have standing to seek it now, even though your client has received a judgment. The standard for reversal of a denial of a motion for class certification for abuse of discretion, correct?
Correct.
Now, there was a hearing on your motion for class certification,
That was.
and there's no transcript of that hearing in the record.
I don't believe there is, Your Honor.
Okay, so all we have is Judge Henry's kind of, one sentence order saying no numerosity, no typicality, all the factors goes through, right? But we don't actually know, how do we rule that Judge Henry abused discretion if there's really no basis in the record for us to assess what his decision was other than this very short order? That's the problem I have with your position.
Looking at the pre-printed forms, one can see that these were not forms unique to Ms. Tuli. These were forms used for all the tenants of this complex and potentially for the other complexes that AvalonBay dealt with. What Judge Henry should have allowed was class discovery.
But we actually don't know his reasoning. His reasoning might well have been evident to us if we were able to look at the hearing transcript, but you didn't put that into the record. So all we have to go on is the bottom line order that he issued, and that really kind of limits our ability to determine whether it was abuse of discretion.
Understood, Your Honor. The issue, our argument, Mr. Tuli's argument would be that the documents themselves, which are pre-printed forms, give support that this is a general routine practice of AvalonBay. Also, the issue for the security deposit itself, the issue was raised, where is that money deposited? And in the motion for class certification, we got the records through a keeper of the records request from the Bank of America, and they indicate that the account was a corporate account. It was an asset of the corporate entity. It was not free and separate from possible lien of Bank of America's accounts. If they open the account as a corporate account, then it's subject to lien if there's any claims against that entity, against that bank.
Where is that in the record?
That is in the record appendix, volume 1, 268. That is one of the documents acquired from Bank of America in the keeper of the records request. And looking at that document, it indicates that it's a corporate account for AvalonBay Communities, Inc. So that would suggest that that account was opened under an EIN of the corporate entity, the landlord, and therefore would not be free of a potential lien. That was one argument we made.
So was your position basically that each tenant's money needed to be in I forget the word for it, I was a landlord.
Escrow?
Yeah, but it's like a trust account, it's in the name of the tenant, but it's only the landlord can take the money.
I think it needs to be in order to be free of the assets of the landlord. If the landlord uses, unless you can set up a trust that has no ability to be sued because it owns no property, has no employees, and put the money into that kind of account. If you open an account with the EIN of the corporate entity or of the landlord or the LLC, then if that entity is sued and has no assets to pay a judgment, then those assets could be seized because they're in the name of the entity. That violates 115B.
So on the form that was the condition statement, where is that in the record?
The move-in, move-out is at Appendix 273, Record Appendix Volume 1. And then looking at 271 and 277 are the other relevant documents that were filled out at the point in time that Mr. Tuli was going to leave the apartment. And these talk about pre-printed forms of standard charges that they would make for cleaning, apartment cleaning, partial painting, etc. Not things that are damaged.
Can anybody from AvalonBay testify, oh, we use this form with every tenant?
AvalonBay, as I recall, did not put on any witnesses at the trial.
Well, no, but it's your burden for class certification, isn't it?
Correct.
Did you offer any evidence that AvalonBay used this particular form? I mean, I agree with you, it probably seems reasonable that they used, this is a big landlord, right? This is not like a 2-unit house. This is a complex, right?
This is a complex, and there are multiple complexes.
Right.
We sought specific discovery related to being able to document that and show the judge the discovery, and we were denied the discovery.
Well, it's a little more complicated than that, right? So you initially seek discovery beyond Ms. Tatuli's claims, right? And,
Correct.
And the Avalonbay objects and moves for protective order, and you don't oppose that, right? So discovery is then cabined to your client's experience, and then when you move for class certification, you say, we've been denied discovery beyond our individual client, and that's their reason that the court should certify the class. But you actually don't request class-based discovery at that point after kind of not fighting the motion for protective order. Is that an accurate
We didn't
account?
fight the motion for protective order, Your Honor, at that time because we had not yet moved for class certification, and there was some validity that at that moment it was just, even though it was pled as a putative class, it was an individual case. But when we filed the motion for class certification, we emphasized the importance of getting class discovery.
Yeah, but you didn't actually, I think you request that the court schedule a status conference to resolve issues of class discovery in your motion, right? But there's nothing beyond that of actually saying, Judge, you need to give us, before you rule in class certification, you need to give us some initial discovery so that we can present to you that we satisfy the numerosity, commonality requirements like that. That didn't happen, right?
And our argument is that we were denied, one, the class certification, and two, there was no order allowed by the court to get class discovery. We asked for the status conference so that we could discuss the need for class discovery. The court's decision had been none of these issues are issues other than for Ms. Tatuli. So if, for example, Ms. Tatuli had deductions from her security deposit because there were burn holes from cigarettes in her carpet, that would be unique to Ms. Tatuli's apartment. But that's not what the case was. It was generalized cleaning, and it was described in these forms that I just referenced the pages to as generalized cleaning and generalized painting. In the one charge, 140 was for general apartment cleaning, and the 105 was for carpet shampooing. None of those things are damages and don't fall in under the statute for 15B.
I guess, I'm sorry, go ahead.
Well, is there an order that you are appealing on discovery?
There is not a specific order because the judge denied the issue of class certification, so we could not get class certification to get discovery, and he did not allow class discovery, and we asked for a status to...
Usually you take discovery before you seek class certification.
In some cases, you do take discovery in order for the court can order discovery. Rodriguez versus Banco, the court can order a limited class discovery in order to assist the court to decide whether the case is suitable for class certification or not, or the judge can class certify and then allow open class discovery.
Right, but in Rodriguez, there was a request for limited class discovery, and there isn't the denial of such a request before us, unfortunately.
Not a specific denial, because it was a request for status to bring that to the judge's attention, and that was not allowed by the court.
Okay.
So the issue...
Did that come up at the hearing that we don't have a transcript for? Did you all discuss limited class?
My recollection is that we discussed the fact that we had not been able to get the class discovery, that AvalonBay had denied it. There was the protective order initially, which we had not opposed because we were going to fight that battle at the time of the motion to class certify when it would be most appropriate to do so, because at the time that it was just an individual case, the argument was it was a fishing expedition. Our argument was it's not a fishing expedition. These are not unique to Mr. Tuli. These are your pre-printed forms. It is your bank that says that you have a corporate account for the security deposits. It's your printed forms that say that you're making cleaning charges and painting charges and that you do this as a routine because that's your pre-printed form. It's not just unique to Mr. Tuli, so we should be able to argue on behalf of all the tenants to make AvalonBay realize that the law means what the law says. You cannot make those kinds of deductions.
Was there any evidence presented to the judge that other tenants had faced similar charges?
We did not have any information relative to other tenants. Mr. Tuli was living under a voucher program, was of very significant limited financial means. She was not familiar, or in the time she lived there, had not formed a lot of relations with other tenants to have any other information. That's why we tried to seek that through discovery.
You can use your remaining 55 seconds.
Well, Mr. Tuli obviously is arguing that she should have the right. Obviously, the trial judge felt that she was correct, that there were multiple violations. He says that specifically and expressly in his memorandum and decision, multiple violations of Chapter 15B, Section 15B. And what Ms. TATULI wanted to do was not only to represent her own interests and losses, but she wanted to have the interests of all the other tenants heard with it at the same time to represent their interests, because the amount of money, $245, that's not even going to equal a filing fee in service of a complaint. None of these tenants would be able, with the practice that AvalonBay had, to have their grievances redressed unless someone were willing to come forward and try and do it as a class action. Thank you, Your Honor.
Counsel, can you speak to why it took so long to get here? Appellee will argue perhaps that they're prejudiced by this delay in addition to the matter being waived, the issue being waived, but why did it take so long to get here? Do you know? There
was apparently a problem with the court that heard the case, getting records done and the record assembled, and there had to be motions then put to kind of prompt the clerk to get the record assembled so that this could move forward. That was one of the delays. Obviously, the pandemic was part of the delay.
Very good.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court, Stephen Weil for the Appellee AvalonBay Communities. On behalf of AvalonBay, we ask that you affirm the denial of Ms. TATULI's motion for class certification. And there are three main reasons that we have in support of that request. The first is that in the 5 years between the filing of the complaint and the decision on the motion for class certification, Ms. TATULI's counsel never pursued class discovery, and it wasn't because the court denied him the opportunity to do that, and I'll speak to that more in a second. Secondly...
Well, before you get off that one, that's not entirely true, right? The plaintiff made an initial request for class certification in her complaint, and then she sought discovery about people's situations, other tenant situations beyond herself, and AvalonBay objected and moved for a protective order. And they didn't oppose that, but there was an initial effort to get broader discovery that you resisted. And then, unfortunately, afterwards, I think for Ms. TATULI, they didn't renew their request formally for class-wide discovery, even limited discovery. Would you agree with that kind of chronology?
Mostly, Your Honor. Let me explain. You're correct that we did file a motion for a protective order initially because we felt that Ms. TATULI's claims themselves lacked merit, let alone opening up the case to a large volume of class discovery. That was very early on in the case, really when the first request for production documents was made. But understand that over the 4-year period that it took to get to that hearing for class certification, there was substantial discovery that took place. There were 4 requests for production of documents. There were 2 sets of admission requests. There were 3 different rafts of keeper of the record subpoenas that went out at different times, totaling 18 different keeper of the record subpoenas.
But did you produce evidence for other tenants?
We did not, Your Honor.
Okay, so then it doesn't matter how many other discovery requests. If you didn't produce evidence that went beyond Ms. TATULI's situation, then
correct.
There's no. Okay,
correct.
Go ahead.
Right, but the point is that not only did the protective order remain in effect during all that time, but there was never a motion to compel, there was never a request for a class discovery schedule. There was simply them trying to show that Ms. TATULI's individual claims had merit, and they never sought the discovery. The judge never denied them class discovery. And as a result, it's really the second reason, by the time we got to the hearing for class certification, there was no evidence on which to form a reasonable belief that Ms. TATULI's claims were typical of any other tenants, or if they were typical, the number of tenants that were involved, or whether there were common questions. There was only individualized issues.
So on that point, I looked at your opposition. You were trial counsel as well?
I was counsel up until the hearing on the motion for certification. There was another attorney in my office who tried the case.
I looked at AvalonBay's opposition to
Yes.
class certification, and it is entirely based on the premise that Ms. Tatuli's claims have no merit, right? Should be rejected because her claims have no merit, no commonality or typicality because her claims have no merit, no numerosity because no one else could possibly have, her claims don't have merit. There was no real defense based on lack of numerosity, lack of typicality, assuming that her claims did have merit, which Judge Krupp ultimately ruled that they did. So I guess the problem I think with this case is that this does seem to be the kind of case where class certification does make sense as a general rule because of the economics of bringing this kind of challenge. We are only recovering at several $100s for each individual person. But if there is some kind of structural problem, that's why you have the class certification device. I did not see any kind of opposition to class certification based on the actual requirements under Rule 23, other than we don't think her claim has any merit.
We did argue, Your Honor, both, and largely that the underlying individualized claims didn't have merit, but we also argued that the request for class certification was based on speculation, because there was no discovery, there was no reason for the judge to believe that any of those criteria were satisfied. And that's essentially what he ruled. No typicality, no numerosity, no common issues.
But just for example, if your numerosity argument was, Tatuli has presented no actual evidence to support her allegations that other Avalon Bay tenants were wrongfully charged to repair, wear, and tear of their apartments. But she was, right? That's what Judge Krupp found. She was wrongfully charged for wear and tear. And so you're saying, well, there's no evidence to her, and there's just speculation to think that anyone else has the same problem too.
That part of the case was primarily an individualized determination. In other words, Ms. Tuli claimed that, oh no, my apartment wasn't damaged, it was just reasonable wear and tear. Avalon Bay had evidence on the other side that no, there were stains in the carpet, there were excessively dirty appliances in the kitchen, and
you lost on those claims.
We lost on those claims, but not at
Tatuli, right?
Not at the motion for
ultimately you lost
stage.
At the merit stage.
Right.
The judge ruled against you.
And just to go to the trial itself, once the motion for certification was denied, the case really became about a $245 deduction from a security deposit. Avalon Bay didn't even, there was no witness called for Avalon Bay. It was simply Ms. Tuli's testimony.
But you didn't settle, you went to judgment and lost.
We tried, Your Honor, it's not on the record, we obviously tried, but it went to trial. He found that Ms. Tuli had individual claims for violations of the, for cleaning costs, for what was reasonable wear and tear. But I also want to add that just with respect to what's been presented to you on the corporate account for the security deposit, the judge ruled that that was not a violation. That was a separate, sure, it was a corporate account, but it was a separate corporate security deposit account that was set up by the Bank of America to hold Avalon Bay tenant security deposits. So there was no finding for Mr. Tuli on that issue. And there were several other issues that he didn't find for. But I think the main point, the central point is, it wasn't Avalon Bay's...
You're saying Massachusetts law does not require the landlord to hold the money in a separate interest-bearing account under the tenant's social security number?
I'm saying, Your Honor, that the law, and there is case law on this, permits a landlord to, it has to be in a separate interest-bearing account, but it can be in a separate interest-bearing account that holds security deposits cumulatively. And that's been established.
What would keep a creditor from attaching a lien to this account?
That's the whole design of a separate interest-bearing account. Whether it's individual or cumulative, it is beyond the reach of the corporation or the landlord's creditors.
Right, I'm trying to understand in looking at this form, what puts it beyond the reach?
I think
It's a corporate account.
There are
It's
other...
Their tax ID number. It doesn't, I mean, it does say security deposit escrow on this form.
Yeah, that was the nature of the account. There are several records that describe that account, but if you look at trial judge's findings, you'll see that he found it was a separate account that creditors couldn't reach. And there was a second witness that Mr. Tuli called from the Bank of America to get these forms into evidence. So there were some questions in the transcript, in the record of that witness, Bank of America's witness. In the end, he found that it was a separate interest-bearing account that met the requirements of the statute. So, and that issue is not up on appeal before you.
So what is the basis in the record for Judge Henry's decision that TATULI's claims were not typical of the purported class claims?
I think the best answer to that, Your Honor, is to refer you to a case that's almost identical to this one that this court decided in 2020. It's the Henry versus Bizzuto management case. And it's almost identical because in that case, the Henrys brought claims against their landlord that unlawful deductions had been made from their security deposit. They purported to represent a class. They claimed that there were problems with the forms that were used. And the motion for class certification was denied by the court because there was no evidence to show that there was any other tenants that had experienced the same thing. The form wasn't enough. There was no evidence as to the policy of the landlord. You know, the misapplication of a policy, which AvalonBay's in the record has said its policy was not to deduct cleaning costs but only damage. The misapplication of a policy is not grounds for class action. So in that Henry versus...
So you say when the Judge Krupp found that AvalonBay violated the statute by subtracting from the plaintiff's security deposit amounts incurred for routine apartment cleaning and carpet cleaning prior to reletting the unit, that was a one-time occurrence? That wasn't evidence of any policy at the
Correct, Your
facility?
Honor. So I'm saying that Henry case is literally on point because even though there was a form, this court affirmed the denial of the motion for class certification because there was no evidence as to whether there was even one other tenant who had suffered.
Well, there was no evidence in part because the plaintiff was not able to gather evidence regarding other tenants, right? I mean, it's a little...
Well, it's not so... Excuse me, Your Honor.
It's a little bit of the chicken and the egg. I mean, you know, that's the problem here, right? And maybe TATULI didn't, unfortunately, go through all the right procedural things to get limited discovery, but it seems unfair to sort of conclude that there was no typicality because she did not have any other evidence as to the other tenants when your client denied that evidence to her.
I think, Your Honor, there needs to be a reasonable basis for the trial court to conclude that, yes, this happened to 1, 10, 100. There was nothing. And essentially what Mr. Tuli is asking is for AvalonBay to have done his job to ask that the protective order be lifted, file a motion to compel, ask the judge to allow him to do class discovery. None of that is in the record, and there's a 4-year period between the time the complaint is filed and the motion is heard. And then, if I may, Your Honor, I would just add to the point well, two other points. One is, at the trial, post the denial of the motion, Mr. Tuli's counsel asked the judge at the beginning of the trial, we'd ask you to reconsider the class certification as the evidence comes in, whether we are producing evidence that justifies that this is appropriate to a class action. And the trial judge responded, and he said, I'm not going to reconsider. That's for the judge who made that decision. But then he goes on and says, right now before me is Mr. Tuli's individual claim. I think it's unfair to the defendant to have me reconsider the question of class certification depending on the evidence because they're prepared to try the claim by Mr. Tuli individually. They're not prepared to try the class certification claim. And that was true. I mean, by the time we got to trial, there was no issue of class certification. It had been denied. We were trying a single question of whether there were proper deductions made from her security deposit. And that was what the trial was about. So, you know, this is my final point, Your Honor, to send it back now to do discovery on the class that they're seeking to certify would be hugely prejudicial to AvalonBay because you're talking about a case that was filed on December 31st of 2012. It took 5 years to get to trial. It took another 6 years for them to docket the appeal. I think largely because there was a delay in getting the evidence transcribed. So we're now 12 years beyond the time of the complaint, looking at a period that would go back 6 years before the complaint. And just by the passage of time, many of the properties that they're claiming are.
I get your argument as to the that issue about the delay, but you're not actually arguing, are you, that the request for class certification is moot, because you can't argue that under the Gamella case? Is that right?
I'm arguing that it would be prejudicial.
Prejudicial, but you're not arguing mootness, right? Then the SJC held in Gamella versus P.F. Chang's that even if a named plaintiff's individual claim is rendered moot, class claims remain live. And so this would be their opportunity. If they had a meritorious argument for abuse of discretion, we could reverse the motion judge's decision at this point, right?
Correct. I'm not making that argument.
Yes.
If that's all, Your Honor, then I rest on our brief.
Thank you very much. The case is submitted.
Thank
I think
you.
we understand everyone's positions. Our next case is 2024, bless you, P509, KOJUHAROVA versus Stefanov. We will hear first from Ms. KOJUHAROVA. The case is partially impounded.
Good morning, Your Honors. May it please the Court. My name is Vanja KOJUHAROVA, and I'm the appellant and the mother. Your Honors, I ask for your patience as I read my argument to ensure that I present it as clearly as possible. This is a case about child support, where every single dollar counts, and the difference between one order and another could mean whether the mother, the custodial parent of the party's young twin boys, could provide for her children while paying support for her daughter living with the father. At the time of trial, the party's daughter was 17 and the twin boys were 9. The question for this court is whether the trial court erred in 3 ways. First, by miscalculating father's gross income for child support. Second, by excluding more than 9 months from its retroactive child support order. And third, by attributing additional income to mother. In 2023 judgment, the trial court's calculation of the father's gross income erroneously excluded several key sources of income. The father's 401k employer match contributions, as well as all his non-taxable income. Some of father's earned income for 2022. The court also set a yearly bonus amount.
I'm going to stop you and ask you a question. I understand your argument about the employer retirement contributions, and I understand what the Kavanaugh case says. But are you saying there were other employer payments that the judge improperly excluded?
Yes, there were some non-taxable employer payments, not very much.
Can you give me an example?
Well, there were some, basically on his pay stubs, based on his pay stubs, there were some COVID payments, there were some transportation payments, and also because basically the trial judge based her calculations on his W-2, which excludes the non-taxable items. Basically, even his own 401 contributions, as well as the 401k employer contributions to his account. That's where the difference comes.
Okay, so you're saying by using, like, let's just keep simple numbers here. Like, assume somebody's income is $100,000, but they put $10,000 in their 401k. By using the W-2, the judge was just looking at $90,000.
Yes.
Okay.
Yes, Your Honor. The court also set an early bonus amount for father, considering only a single bonus payment in March of 2023, disregarding the fact that historically, father received bonuses several times a year, and that his bonuses historically exceeded $20,000 per year. In Massachusetts, employer contributions to retirement plans, 401k plans, one of them, and other non-taxable income are considered income, even though they are not on the W-2 form. The trial court relied on father's financial statement submitted to the court when father testified that he excluded his 401k income and the partial income in 2022, and testified that he intentionally excluded bonuses for child support purposes from his financial statements. However, the evidence before the court, including pay stubs and father's testimony, clearly established those amounts, and their exclusion from the child support calculation was an error.
So the judge found that, the judge's order says that as for the 2023 bonus money, which she didn't know the full scope of because this decision was only partway through 2023, she suggests the parties find a way to future resolutions of child support based on exchanging information, and I think impliedly behaving reasonably. Did that happen in 2023 after this decision?
No error. It has never happened.
Okay.
And also, I wanted to add to the
So
bonus.
is there a new request for modification pending?
No, it's just this appeal pending.
Okay.
And considering the fluctuating nature of the bonuses, Your Honors, the court also erred in plugging a fixed amount into the guidelines rather than ordering a percentage of the bonuses as additional child support for the children, as is typically done, as child support has been modified numerous times, but the essential premise has remained consistent that child support should be calculated as percentage of a parent's income.
On the question of retroactivity, the judge found that the father had only realized his current income by the end of 2022, and so then she issued retroactive payments starting in 2023. Why was that an abuse of discretion or an error?
Your Honor, first because the trial court found that there was a material change of circumstances, and that according to the guidelines, instead of mother paying child support, she should be receiving child support, and the difference was $200 per week, which that fact alone showed that father had been substantially underpaying for the support for the young boys in mother's care. And the date that, the lower court made no finding that ordering full retroactive support would be contrary to the children's best interest. So the date that she chose, the first Friday in 2023, to begin the retroactive support, stating, as you said, that by that time the father has fully, I forget the exact quote, but that she found that she's basing the child support order based on this income. It seems arbitrary at best. It doesn't have any support on the record. As such, the lower court's exclusion of 9 months from its retroactive support order was an error. Okay, so I'm continuing to the attribution of income error. Your Honors, I'd like to set the record straight. This is a split custody case. In 2021, the parties split the children, with father having custody of the then 15-year-old daughter and mother having custody of the 7-year-old boys. The 21 judgment ordered non-custodial parenting time for mother during her workday. The same judgment ordered transportation for parenting time also during mother's workday. The 23 trial court's justification for attributing additional income to mother was flawed in several respects. First, the trial judge relied on a prior finding that the twin boys attend school full-time. However, the full-time school in Arlington Elementary Schools is from 8 a.m. until 1 p.m. once a week, and from 8 a.m. until 2:30 p.m. 4 days a week, with some early dismissals at 11:30 and 12 weeks of school vacations when school vacation program start at 9 o'clock and typically end at 3. After school and extended day vacation programs are not guaranteed, and mother needs to apply for them several times a year. Undisputedly, mother is responsible for the majority of the care of the young twin boys during the work week without help from the father or a living babysitter. The lower court, in attributing
So, ma'am, was that school schedule before this judge?
That's the public elementary schools schedule, and it has always been the same.
Okay.
Yeah. The lower court, in attributing additional income to mother, failed to explain how mother could reasonably increase her income, considering her child care duties, both custodial and non-custodial, and her employer's work hours. Judge's statement, Your Honors, that mother voluntarily works less, despite the additional work available to her, is clearly erroneous. This statement could be interpreted as promoting a policy that parents must work regardless of availability or reasonableness, or even during court-ordered parenting time, effectively precluding parenting time. The child support guidelines explicitly asks the courts to consider the age, number, needs, and care of the children. The evidence before the court made it clear that a 100% full-time work schedule and mother's custodial and non-custodial parenting obligations were in direct conflict. Furthermore, judge's finding that other work was available to mother was unsupported by the evidence. In 2023, at the time of trial, and since mother's only available offer of employment has been the one that mother is employed at. For all these reasons, the trial court erred in calculating father's and mother's income for child support purposes and excluded 9 months from its retroactive support order and lowering the child support for mother's custodial children. If there are no further questions, Your Honors, I would rest on my brief and reply brief. Thank you, Your Honors.
Thank you.
Thank you very much.
Good morning, Your Honors. Emma Hobbs representing Peter Stefanov, the father in the pending matter. Today, we're asking you to uphold Judge Monk's decision on the 2023 modification. If I can start on mother's attribution of income, it's clearly within Judge Monk's discretion to do so. Judge Monk specifically found that there had not been a substantial and material change in circumstance from the 2021 judgment, which of course is the standard to be able to grant modification.
Let's just leave the mother aside for the moment.
Yes.
Let's say hypothetically, school runs from 8 a.m. to 2:30. and the parent has a job that runs 9 to 5, or they can do 9 to 3. All right, so what is when the judge says, if you choose 9 to 3, that's you choosing that voluntarily, I'm trying to understand what a layperson would take from that.
Yes, absolutely, Your Honor. Most parents work 9 to 5 jobs. There are lots of after-school care programs. The party's income is clearly sufficient to be able to afford after-school care if needed. Mother has been sacrificing about $20,000 in income, and that is more than enough to cover any after-school care costs. Parents do this all the time, and the probate court is well familiar.
The idea is that it's all on mother, that all the aftercare and summer camp that's not covered by father's vacation?
I think the parties have had previous agreements to share extracurricular costs, and I don't think it would be out of the question for father to help share in those costs, but instead mother unilaterally decided to voluntarily reduce her income. And mother cited numerous times in her brief that a parent is not able to waive a child support obligation on behalf of the child, but that's exactly what mother does when she chooses to take less income. She cites transportation issues and says it takes her an hour and a half to get to the school because she takes the bus and a train. The cost of a parking spot next to Harvard is $1,500 a year, maybe $2,000, which again, she's leaving $20,000 on the table that could be used to provide for the children and instead placing that responsibility on father. If we were to talk about retroactive support as well, it's also—
Before we get to retroactive support, it seems that Kavanaugh is specifically on point on the employer contributions and that it requires the judge to have considered employer contributions. What do you say to that?
Yes, Your Honor. So Kavanaugh specifically says that it was not an error for the lower court to consider the 401k contributions. Kavanaugh has not been clear on whether that requires 401ks to always be included as income. We would note that the child
Kavanaugh
support—
says, we therefore conclude that employer contributions to a retirement account constitute income for the purposes of calculating child support. What's ambiguous about that?
Yes, it does. I mean, the next sentence says that it was not an error in the present
Not
case.
abuse of discretion, using, yes, but that's the
Yeah.
first sentence, that's the holding. Right?
Yeah.
So it's not really up for debate, right? And you don't actually say that in your brief, which is, I think, concerning.
Our concern is that it has not been implemented in that way at the probate court. We would note that the child support guidelines were updated after Kavanaugh, and they did not require 401k contributions to be considered as income.
Can I just ask you, your brief, page 7, you say the court, you're talking about Kavanaugh, you say the court did not conclude that employer contributions to 401k plans must be included as income under the child support guidelines. That's not true, is it?
I think our reading of it is whether it's a must. In Kavanaugh, it doesn't indicate— the language says in that present case that it should be counted as income.
And then you say the exact opposite. I mean, these statements seem diametrically opposed to each other.
Our concern is that it hasn't been implemented as—
It doesn't matter if it's implemented. You are summarizing the holding of a Supreme Judicial Court ruling that's directly on point, and you're misstating the ruling here. It's not a question about how it's been implemented or what it means in reality. You were actually summarizing the holding of the SJC incorrectly.
It's our understanding that there isn't a must in there, and it's unclear—
We therefore conclude that employer contributions to a retirement account constitute income for purposes of calculating child support. You don't think that's a must?
We're not sure if it is a must. We don't think the Kavanaugh court specified that it must be applied in every case.
If that was your argument, you need to be a little more candid about your efforts to distinguish the holding and not just ignore it and say the court didn't hold that.
Yes, Your Honor, it's also our concern that in the Kavanaugh decision, when they reached that conclusion, they specifically noted that they were concerned that 401k contributions by employers could be used to shelter income, prevent it from being applied to child support. Father's 401 employer contributions are exactly in line what a normal 401k contribution would be. There's nothing excessive. It's not clear that father's attempting to hide any income. This is standard. And it's also not clear—
That's a limiting interpretation of what the SJC ruled, but you don't actually make that argument. You just say the SJC didn't hold this when it did.
Yes, Your Honor. It's
You understand my concern about— you have a duty to be candid with the court about summarizing other court decisions, and I'm not sure you did that here.
Yes, Your Honor. I understand. It's our position also that it's not clearly explained in Kavanaugh why exactly it is equitable for income to be considered that is fully inaccessible to father without receiving penalties. He cannot access this until the age of retirement. It's not clear to us why that is equitable for that to be considered income for father.
But it is undisputed that the judge excluded the employer contributions in this case.
Yes, it is.
And it's undisputed that the judge did not include the one-time payout of the unused.
The judge did not include that amount. They didn't find that it was representative of a future income. They specifically averaged the total incomes on the W-2s, which reflect the bonuses if you compare them to father's pay stubs. That total amount.
But do the guidelines use the party's gross income or do they use net income?
It uses the gross income.
Right, so isn't that automatically an error when you use the W-2?
They use the W-2, but it also lines up with the pay stubs. It reflects, the pay stubs reflect exactly the bonus amount. There's a $3,000 difference between the pay stubs and the W-2, which is.
Okay, we're conflating two issues, so we can focus on the pay stubs, but what she's saying, though, is the minute you use the W-2, you are not counting the money he put in his 401K, because that's not on the W-2. Why is she wrong about that?
Yes, Your Honor. It's our understanding equitably that father should be obligated to provide child support in line with the income he actually receives. Income that is inaccessible to him, that can't
But he
be
chose to put the money in the 401K. He could choose not to put the money in the 401K.
Yes, he could. It's a standard part of most employee packages. If he chooses not to invest in his retirement, he's then placing the obligation on his children to care for him later in life if he's unable to save for his own retirement.
The judge made the father's, well, let's go back. On the bonus income, he gets, I'm just going to say, I'm going to just use the number $50,000, which is not the number, but because information's impounded, I just want to keep the number simple. So he gets $50,000 in 2021. Again, he didn't. I'm just using that as hypothetical. He gets $50,000 again in 2022. In 2023, we're only partway through the year, and at that point, he's only gotten, say, like $12,500, right? And the judge then puts that into the average, so immediately you're weighing down the father's income, but because you're putting in, because we know that you're not going to get the full bonus until the end of the year. So by using that partial year, you've automatically biased the calculation, right?
Yes, Your Honor, but Judge Monks does also note that the bonus incomes are not guaranteed and that the amount of hours available to father does vary. But even then, if you look at the amount that works out from spreading that initial bonus over the year, it's almost exactly in line with the previous income that father had received in the previous years. The average is just about in the middle of what father has actually received prior to 2023.
Well, I mean, but that's, so she says she does not make his payment fully retroactive because he had more fully realized the average income by the end of 2022. But when you actually look at the three numbers, that's just not correct, right?
So throughout 2022, in the middle of the year, his pay stub reflects that he was getting $904 every 2 weeks. By the end of 2022, it's closer to $1,633, which is the income approximately, I think there's $20, give or take, that father was actually making.
Okay, because if you look at the total numbers are fairly similar for the 3 years. So I don't know why the W-2 would show a lower number partway through the year for 2022. I mean, it seems like there's a distortion if you're looking, and that's a place where if you look at the pay stub, maybe it's not accurate, but if you look at the annual total, he was fully realizing the annual total much earlier than the end of 2022.
So part of the issue with 2022 also was that his hours were different because of the takeover of his company and the sale of his company. But father's weekly income, which is generally what we want reflective of a child support amount, was much less at that time period. But we would also note that it's fully at the discretion of the trial court judges to determine what an appropriate amount of retroactive support is. Bolter very clearly says that retroactive support is not required, and it's not even the standard.
Which case are you citing for that?
I'm citing Bolter, B-O-U-L-T-E-R.
Yeah, I mean, the problem is, I have to say, on this point, the case law is less than ideal, because we've got both, there's an SJC decision after Bolter, and there's also a decision from our Whalen versus Whalen from our court that seems to sort of have it both ways. The judge is not required to make a modification at retroactive, but absent a specific finding that retroactivity would be contrary to the child's best interest, unjust, or inappropriate, these factors, and I can't even tell what these factors are, I guess whether it's in the best interest, it's unjust or inappropriate, but I'm not really sure, should be considered. And the only consideration I see here is that the judge says that by the end of 2022, he had more fully realized the average income found by the court. But he had fully realized it in 2021. There's this anomaly where his company sort of seems to repurpose itself into a new company, but it seems to be the same company.
Yeah, it was an odd situation. But for us, it's clear that the case law recommends that a judge perhaps consider these factors. And the judge did consider whether it was appropriate in light of the circumstances and did waive mother's support and asked father to pay that back for the time period from the date of service, and found that that was an equitable way to break it down, to accurately reflect what father was able to earn at different times, and make sure also that mother's child support obligation that we found had changed was able to be paid back to her.
So if a parent's obligation, if a parent's income isn't a steady line throughout the year, but there's a dip, but then at the end of the year they come back and they have the exact same income they've had, why, I'm just not understanding why that falls on the other parent.
Why it falls on the other parent to have
to get a lower amount of child support.
Well, I think in here it wasn't reflective that she ended up getting a lower amount of child support. She ended up with exactly the average of the child support. Was that for those period of 9 months, the judge didn't?
Though. Then it would have been fully retroactive.
We believe that the retroactive support is not required, but even then that.
I get that message, right? But if we disagree with you, I mean, here's the thing. Let's assume for the moment that his income was $100,000 each year for the 3 years, but that because of this corporate reorganization, instead of getting an equal, let's make it $120,000 for easy math, instead of getting $10,000 a month for that 2020 year, 21, he gets $5,000 for 6 months, but then it's made up, right? So he ends up the same, but under this, she ends up with a whole lot less. She didn't do anything. So why is that just?
Yes, so it's my understanding also this was during the modification, and during the period of modification, the judge is considering the specific circumstances of the parties at that time. The specific circumstances demonstrated that father had a far less income. By the time trial finally came around, his income had corrected.
If you look at the number, he didn't.
He did during that part of the year, and I think that was part of the judge's consideration.
By that time, 2022 was over. He ends up with more money than in 2021, even when you factor in the improper exclusion. And so it's just wrong. I mean, tell me how it's not wrong, because I'm trying to understand I get that there was this corporate reorganization and maybe his money was fluctuating, but in the end, at the end of 2022, he has more money than he had in 2021.
Yeah, and that income is then used to calculate and push up the average of his income that may not be representative of future income, but that during that time.
Oh, it looks like it's going to actually be less than 2023. If he gets the exact same bonus he got in 2021 and 2022, then he's going to make a lot more money in 2023. But in fact, oddly, because the judge used that partial bonus, it drove down the average without accounting for the fact that he's going to end up where he did in 2023.
I think the judge also notes, though, that those bonuses are highly variable and that his hours are
Right, they
highly.
were there was an element of the bonus that was the same, and since she hasn't already gone and moved for a modification, she's missing out on that money, as if she had gone and proceeded in parallel and sought a modification, that 2023 money would be on the table.
Yes, I think it was the concern that his hours are highly variable, that some of the bonuses are dependent on those hours. And so
This is what I don't understand, though. You keep saying his hours were highly variable, but his money, his income was not. He made more money in 2022 than he made in 2021, and we don't know yet about 2023. But if he got the exact same bonus, there were two pieces to the bonus in 1 year, but in both 2021 and 2022, there was a second bonus that was exactly the same. If he got that bonus again in 2023, then his income would even be more in 2023.
Yes, I think part of our concern is also that the trial court does have discretion to determine what feels like an accurate representation of bonus income. And of course, as you noted earlier, the judge did encourage the parties and wish that they had previously found a scheme to better account for changes in income.
Well,
But
should the judge have done what the mother suggested and just say, here's the percentage of his bonus income that he needs to pay over for child support?
we think it really varies in different cases. The judge absolutely could have, and we also had hoped that the parties would be able to be together and find ways to accurately reflect income or help provide for different activities or childcare, as the mother had indicated, but those conversations never ended up coming to fruition. But we do believe fundamentally that the judge had the discretion to identify what an appropriate average income would be for father, which was pretty closely reflected on both his pay stubs and his W-2s.
Do you have any questions? All right, we understand both sides' arguments. I think you've made it very clear, and the case is submitted.
Thank you, Your Honor.
I think that takes us then to our last case for the morning, 2024 P340 Arslen versus Kettlebrook Lofts Condominium Trust.
May it please the Court, Your Honors, Thomas Moriarty for the Kettlebrook Lofts Condominium Trust. This is on appeal from trial court's grant of summary judgment in favor of the plaintiffs. The trial court decision should be reversed as the condominium trust properly and reasonably exercised its power to eliminate the threat posed by the plaintiff's presence at the condominium. The first point the condominium trust would make is that it's beyond question that Mr. Arslen breached his duty as a unit owner by beating Mr. Golub with a tire iron. Mr. Arslen agreed.
So I'm going to pause you on, obviously, nobody thinks it's a good idea that a condo owner or anyone beats somebody else with their fists or a crowbar. But I want to make sure we shake hands with some of the facts in this case. Does he still own the unit at issue?
Yes, Your Honor.
And there seemed to be and has he participated in any physical altercation since the underlying assault here?
Not that have been reported to the condominium trust, Your Honor, and there's no fact that suggests otherwise.
Okay. And he seems to indicate that even if he wanted to sell, or that he did want to sell, but he can't or he couldn't because there was some litigation involving the condominium and the developer. Is that accurate?
No, Your Honor, there was. Historically, that case has been resolved by a decision of the appeals court years ago.
Was it resolved before this?
Before this case was filed?
Yeah, when he was, because at some point right after this, the condominium issued this order, he, according to what I read, he seemed to indicate he was trying to sell, but he couldn't because of ongoing litigation at that time.
Your
Is
Honor,
that accurate?
I can't say whether that's accurate or not. It's possible that the appeals court decision in that case came down after the incident. I'm not sure. I can certainly provide those dates to the court, but Your Honor.
I'm asking because you argue, well, he could always sell his unit, and if that's not accurate, then that is important.
That case has been resolved for quite some time, so there is
Okay.
no impediment to Mr. Arslen selling his unit. Of course, he always could have rented it as well, Your Honor. Mr. Arslen was bound by the condominium governance documents by agreeing to accept a deed to a unit at Kettlebrook's Loft condominium. He surrendered certain rights in connection with acquiring that unit, and not that he was otherwise authorized to beat Mr. Golub with a tire iron, but he did accept the consequences from engaging in that behavior, including the consequences that the documents and the law would afford the condominium trust in that circumstance. Section 4 of General Law 183A says that each unit owner must comply with the bylaws, the rules and regulations, the master deed, and the deed restrictions that are contained in their unit deed. Most specifically, Rule 5, which is incorporated into the Declaration of Trust of the condominium, provides that no unit owner shall do himself, either willfully or negligently, an action which interferes with the rights of other unit owners.
Did you make the Rule 5 argument below?
Yes, Your Honor.
Where is that in the record, do you know? If you don't, we'll find it, but.
I do not off the top of my head know. It would be in the memorandum in support of the cross motion for summary judgment and in opposition to Mr.
We'll find it,
Arslen's
we'll find
motion.
it.
So in that regard, there is no question that a unit owner is not at liberty to beat another unit owner on the common area of the condominium. So in that respect, it should be beyond question that Mr. Arslen is in violation of his obligations as a unit owner. The question then becomes, what is the reasonable resolution of that? What is the reasonable consequence stemming from that violative behavior?
Well, I mean, you argue that whatever power the condominium trust has, it cannot exercise its power unreasonably, and I'm wondering what the standard is to determine if it's being unreasonable.
So, Your Honor, as the law presents in numerous circumstances, reasonableness can depend on, and most often does depend on, the facts that are presented. I mean, the basic negligence standard is one of reasonableness. Any condominium action that is undertaken, whether it's rulemaking or it's an enforcement of the governing documents or the rules, is subject to a reasonableness standard. That's the standard that the SJC has applied to condominium associations. It's essentially a lower-level constitutional scrutiny. That's what you get out of the Prue case and the Franklin and Noble cases.
But Counsel, isn't it part of the analysis of whether they're arbitrary against public policy or against constitutional concerns?
So, Your Honor, the trial court did not specifically rely on, and Mr. Arslen, other than saying that he has a property interest in the unit, did not raise constitutional concerns, but clearly constitutional issues are presented with regard to private property. Right? This is a property interest that Mr. Arslen has. It's also a property interest that Mr. Golub has, and it's a property interest that all the other unit owners have. And in this circumstance, there is no question but that the law has vested or left to the community association, the organization of unit owners, the ability and obligation to essentially manage and maintain the common area because the unit owners have intentionally ceded that power to the organization of unit owners.
Right, but let's take that to an extreme. Let's say that somebody has purchased a condominium unit in the condominium building, and before they've moved in, you find out that 10 years ago they had an assault and battery by means of a dangerous weapon conviction. Does that mean the condominium owner can say, no, you can't move in? The trust can say you can't move in?
On those facts, I would think that if an organization of unit owners attempted to do so, the standard would be a reasonableness standard, and it would be much more difficult hurdle for an association to meet a reasonableness standard based on a decades-old violation that did not occur.
What if the person had a recent assault and battery by means of a dangerous weapon, and that condominium trust had forced them out, and so they were trying to find a new place to live? Could the new condominium association say, no, you can't move in?
Certainly a closer question than if it happened 10 years before.
Well, I know, but if we rule the way you're suggesting, we are taking a huge amount of living possibilities off the table for a very high percentage of the people who live in the Commonwealth. I mean, it's pretty broad.
No, Your Honor, I disagree with that, because the standard will always be one of reasonableness. So the question...
Well, you're saying anybody with a recent ABDW can't move in, and I'm not, we could go through the parade of horrible crimes people could commit, but you could say nobody who's got a sex offense could move in. Nobody, I mean, you could just...
Well, you could, that one you could not do, Your Honor, because there is statutory protection for people in certain classes of sexual offender. That issue does come up, quite frankly, in this context of community ownership. But the point, Your Honor, is not that there would be no check on an association's ability. This decision of the trial court makes it an impossibility to consider it, because what the court has said is, because there's no decision previously authorizing it, and because there's no specific grant of authority, there is no power. And the absence of power makes it unreasonable. This court did not undertake the fundamental question that is presented in this circumstance.
Counsel, we reviewed de novo, correct?
Yes, Your Honor.
And we can affirm on anything in the record, correct?
Any arguments that were made below? Yes, Your Honor.
And I want to cut to the chase. Is a person doesn't have an unconditional right to live in his or her own home. For instance, it's not uncommon with restraining orders that a party may be asked to leave or commanded, directed to leave his or her own home because they're a defendant in a restraining order, and they may be forced to leave the residence that they own, correct?
That's correct, Your Honor.
But there's due process there. There's a hearing. They're allowed to be heard, correct?
Yes, Your Honor.
In landlord-tenant actions, when a tenant may agree to a condition in a lease, if there's criminal behavior in the residence, the premises, they may be subject to eviction, correct? So they may be evicted.
Yes, Your Honor.
And there's process with an eviction, correct? There's court
absolutely.
involvement. But you're suggesting that this condo association can just avoid any due process, and based on what they claim are allegations or allegations of serious crime, just deprive someone of their right to live in their home without any due process?
No, Your Honor, because look at what happened in this circumstance. There was a cease and desist letter that was sent, but the board has no independent authority, nor did it attempt to exercise any self-help to remove Mr. Arslan from his unit. In fact, what played out is due process. Mr. Arslan happened to be the plaintiff in the case seeking a declaration, but there was a cross-claim seeking to enforce the cease and desist order and the rules and regulations. What didn't happen in the trial court was an analysis of the reasonableness of the decision-making and exercise of discretion by the board. What the court concluded is there is no authority across the board, meaning definitively, determinatively, such that there does not have to be an analysis of the reasonableness. The condominium trust would argue, I'm sorry, Your Honor.
In the criminal case, the judge said stay X amount away from Mr. Golub, right?
Yes, Your Honor. Well, there was a stay-away order. I don't know if that, in fact, was a consequence of the plea. I know that
In fact, it might have been a stay-away order before.
I believe so, Your Honor,
Right.
but I'm not certain.
But, so you do, on some level, then have a court determination that he doesn't need to vacate the condominium trust, at least for Mr. Golub's safety, right? Because
No, Your Honor. I think that the analysis there and the remedy that's available to Mr. Golub is very different. Mr. Golub would have had no standing whatsoever to seek to evict.
No, I know, but the court, because we do have court orders and restraining orders that might say you know, if they say you have to stay, if they had said he has to stay 500 yards away, maybe the only way to do that would have been to move out. But this order wasn't that, right?
That's true, Your Honor. That's true. But it's unclear from the record and from the condominium trust perspective, really not relevant to the assessment of whether or not a condominium trust can exercise discretion if it is done so reasonably. That's the underlying question here. What's been deprived is any analysis. What the court has concluded is the power doesn't exist definitively, period. And it's a concern that a condominium trust that is charged with, among other things, responsibility for the security and safety of residents and invitees on the common area would not have any opportunity as a matter of law to try to intervene and to assess a circumstance and to exercise reasonable discretion in a circumstance where a violent attack had occurred on the common area.
Well, the judge said, I think initially, that your rules didn't cover this situation, right? He said your Rule 5 refers to noxious and offensive behavior, and he said that's really kind of nuisance type. So initially, there's just an interpretation issue about whether or not your rules and regulations actually speak to this situation. So that kind of that's like the initial question we have to deal with, right? And I understand you disagree with that interpretation, but if you didn't have a rule or regulation that spoke to this issue, then you wouldn't have authority to issue your cease and desist letter. You wouldn't have authority to issue the kind of coercive fines that you did, right? That's kind of the threshold question for us, right?
So, Your Honor, I'd say there are 2 points there. One is we do disagree because there's too narrow a reading placed on Rule 5, because the way that the condominium trust characterized it in my initial statements is accurate. If you parse the language, it's not limited to noxious and offensive uses. There's an independent obligation to refrain from taking action which denies other unit owners their rights. But hypothetically, Your Honor, even if that regulation did not occur or was not contained in the documents, there is a circumstance where an organization of unit owners could act from the condominium trust perspective to protect owners on the common area, because there are other statutory devices and other powers in the master deed. And I know,
but none of those are at issue here, right? You're making an argument that Mr. Arslin had a duty based on kind of the rules and regulations, right? Now, there may be other statutory mechanisms that you can invoke, but that's not. We're only looking at sort of the language of your actual rules and regulations here. So really, we are limited to that as a threshold question, whether you had authority to do this at all. Different question as to whether you had authority under the any means necessary provision to carry out the way you did, right? But that's kind of, in terms of, you're saying, well, it all comes down to reasonableness. It has to be reasonableness focused on authority that your rules and regulations itself delineate, don't you think?
Yes, Your Honor. Based on the arguments that were made below, the plaintiffs or the defendant would accept that completely. I was only addressing the court's broader context.
Well, but like looking at the language of Rule 5, one of the limitations is that you're not supposed to interfere with the rights, comforts, or conveniences of the other unit owners. So let's say somebody habitually double parks and makes it hard for the other people to pull into the condominium parking garage. Could you make them move out of their unit for that?
Completely unreasonable, Your Honor. That would be a completely unreasonable response.
So that's what I'm trying to get at, the why. Why is that unreasonable?
Well, I mean, if that fact pattern were presented, I think any jurist in Massachusetts would look at that and say that there are remedies that are available to a condominium trust far short of preventing someone from occupying their unit, which would include fining, which would include potentially towing. There are all types of other avenues available. And I understand.
Why is it not a middle ground here to say he can't use the common areas except for to come in and to come out? He can't loiter down there. He can't entertain people down there. He's forfeited his use of common areas. He's got to get into his unit, stay in there. Then when he's ready to leave, he leaves.
So 2 points, Your Honor. It is not the condominium trust position that the only remedy available was to remove him from the unit or to request that he vacate the unit. So it's not our position that there couldn't have been other, let's say, less aggressive steps. The point that the condominium trust is advancing and took in the trial court, and quite frankly took when it issued the decision, was that given the circumstances, an unprovoked, isolated attack of another unit owner on the common area, passing and repassing over the common area would not do anything to prevent a similar event. If you're trying to prevent somebody from parking, you can fine them, you can keep towing their car. You don't have to throw them out of their unit. It's the presence on the common area itself that presented the primary concern, Your Honors.
So, just on the subject of fines, why can the condominium trust fine someone for conduct that has ceased? He's not beating up the other unit owner.
Excellent question, Your Honor. The point is the failure to vacate. That's the violation, not the continued beating, Your Honor.
So I'm not saying this is necessarily this case, but we've seen these cases before where a condominium trust just basically crushes a unit owner with daily fines. Like if a judge did this, there would be bad press. And that's an understatement. So why is it okay? Like, it's one thing for you to impose a fine, $100, $1,000, and then you go fight over whether that's appropriate. But like thousands of dollars of fines. And in fact, in your brief, you seem to say that you should be able to have these daily fines all the way through today. Where like it would basically keep a regular, normal human being who's not a, billionaire from litigating their case because they'd just be crushed by the condominium association. Why is that okay?
So this plaintiff could have complied with the order and continued to litigate this case. They are not mutually exclusive, Your Honor. The fine has...
Not really that practical for most people to be able to come and have a new home.
Well, if they were renting the existing home, there'd be an opportunity to use that rent to rent in another location, Your Honor. And again, the question isn't, the condominium trust point would be, this is an exceedingly rare circumstance. This is, you can't find cases like this anywhere in the country from what we could find, something directly on point. So the opportunity for a condominium trust to exercise this type of remedy should be properly extremely limited. There is no question that there is a serious and substantial property right implicated for Mr. Arslin, as there is for Mr. Golub and all of the other property owners. The final point I would make, Your Honor, on that is that, but these folks have voluntarily agreed to cede their individual authority, what they would be able to exercise if they were individual.
I think we understand that point and you're past your time, so, okay. I think we'll have to leave it there and we can hear from Mr. Arslin.
Thank you, Your Honors.
We need you to move over to the microphone.
I'm sorry, Your Honor?
We need you to be at the microphone.
Okay. My name is Ron Arslin, pro se, and I'm here to request following relief, deny defendants, appellants, Kettlebrook Lofts Trust appeal to the appeals court from the judgment and memorandum and order dated January 22nd, 2024 by the Honorable Judge Ritter, and affirm the judgment and court order with prejudice so I can sell my home without interference. The case history, this whole issue speaks for itself, Your Honors. Every motion, counterclaim, application put forth by the defendant appellant pertaining to their efforts to kick me out of my home and find me into financial destitution was denied, not by one, not by two, by three judges.
So, sir, you have done quite well for yourself in the litigation, but his argument is basically that, when you buy into a condominium, you, like the association, you give up certain rights, and that this language here in Rule 5 is very clear that if you interfere with the rights of comforts and convenience of other unit owners, that the condominium association can take significant action, and that by reading that language, you should have understood that probably you don't even need a document to tell you you can't beat up somebody else. So why are they wrong about that?
There were mitigating circumstances.
I understand you're saying that the other guy started it, but
It was an isolated incident and has absolutely nothing to do with the rest of the community. It was one isolated incident that stopped immediately. I've been living there 2.5 years since, and there's been no issues at all.
What about a different situation? If, say, there was someone at your complex who was very dangerous and routinely sort of used physical force against other residents all the time, do you think that the condo trust would have some authority to, what could the condo trust do to deal with that kind of ongoing threat of violence from a resident?
If the person was a habitual, causing trouble all the time, yeah.
What could they do?
And their cease and desist letter, they said they intended to file a temporary restraining order on me, but they never did. They just kept racking up the fines after fine after fine after fine.
Yeah, so we're trying to figure out what authority the condo trust has to handle situations where a unit owner is posing an ongoing risk of violence. And I'm trying to get your sense of what, I know it's not what you think your situation is, but wait, I want to know what your position is as to what they can do in that situation. Are they completely helpless, or can they take measures to sort of protect the other residents?
According to their rules, if you read in the Record Appendix 285, Section 10, I believe, first infraction is a warning. It was one infraction, one warning per infraction. And then if it keeps going, then you get a second warning. But there was no second infraction. It was one. So at worst, me and my counterpart, Aaron Golub, should have gotten warnings.
So, sir,
Not try to kick me out of my home. Is there a condo law on the books in the law of the land in Massachusetts that say they can be kicked out of their home? This is my home, Your Honor. They're trying to throw me out. And if you read page 552 through 554 in the Record Appendix, the judge, Honorable Judge Ritter, he puts it in a nutshell a lot better than I could. And the key sentence was his last sentence in his judgment. The condominium trust lacked the legal authority to preclude the plaintiff from occupying his unit under the rules and regulations, hence any commensurate fine would likewise be unenforceable. Their fines, fees, and attorney costs are generated on their false notion that they can just kick somebody out of their home for one isolated incident.
Did you say you were trying to sell your property, sir?
Yes, I did. And if you go to the Record Appendix, what page is that on? I got it marked down here. Where is it? All right, Record Appendix, page 564. Now, at that time, it was after the incident. My then attorney at the time, I gave this fellow, and I have the proof in my bag too. I gave the fellow 3 extensions because it kept getting delayed. Hold on, 564.
I take it this is an attorney for the person you were trying to sell to?
I'm sorry?
I take it this is an email from the attorney for the person?
That was an email.
Possible buyer?
That was a letter sent from my attorney at the time to Megan Hall. He's the third lawyer they've thrown up against me, so she was the first one.
So are you saying you're attempting to sell?
Here it is, 560.
So are you attempting to sell your unit, and is it being delayed
yes.
by this case?
I attempted to sell it, I had a buyer, and his loan got turned down in December. And I gave the man 3 extensions, and I can show them to you, and they're in my bag. And this is the letter. He got turned down in the end because this is Attorney Rafelson. I received this email from the closing attorney for my client. The condo association is not currently financeable.
Right, what we're
According
asking
to
is,
the government
sir,
standards, because of additional uncompleted phase and ongoing litigation there.
right, but this letter is from December of 2022, which is now more than 2 years ago.
No,
so-
this is not 2022. It was after the incident. It was in between, it had to be in December of 2022.
Yes, it is. So, but 2 years have gone by, plus.
Well, okay, so what happened was, after the third extension, I had to let the guy go. Meanwhile, they're dishing out the fines every day, every week.
We
So by the time-
understand that, but what we're trying to understand is could a buyer finance now? In other words, did the condominium association get its
I can answer
situation
that.
improved?
I can answer that. Currently, yes, my ledger is at 0. And I have a closer attorney and a realtor ready to go. I asked them, since my ledger is at 0, I said, why don't I just sell it now? Their answer was, well, Ron, if you sell it before the appeals process is finished,
I'm going to stop you because I don't want you to tell us any confidential information. Like if,
no, the
it's
HOA,
up to you, but.
No, I'm saying, I'm not selling, I can't sell it now because if I tried to, they would file or could file an injunction to block the sale. And then I'd be mucked into that. That's why.
Well, I could be wrong, but I suspect that they might tell you that that they won't block the sale because they want you to go. Like, would that cover?
They lie.
They lie.
You want an example? I can
they-
give you an example right now how they lie. Let's go to the blue brief, page 31. And, well, first we'll go to the Record Appendix 561. This is a classic example of how they lie. Okay, this is the November 2nd, 2022 letter to my attorney from Megan Hall. And at the bottom of the page, I'll read it to you. As noted in our correspondence dated October 24th, 2022, the September 13th assault and battery was not a singular isolated event, says Megan Hall, but rather a culmination of increasing pattern of disturbing behavior exhibited by Arslen at the condominium for the past 10 months. So they're saying prior to the incident, I was exhibiting disturbing behavior, okay?
Right.
So hold that thought for a minute.
I understand that. But if they were to give you a writing that says that they won't try to block your sale.
You think they're gonna, yeah, but they'll lose him. All right, if he puts it in writing that while my ledger is at 0 and I can sell my place, then And they won't, they won't allow it because they won't do it because they'll lose their money. That's what it's all about, is money.
What,
They don't care about the community.
14,000 or so, or the possibility?
23,000. They would lose $23,000 that they want, plus whatever else they want. If I was able to sell it today without them filing an injunction, they would have to file an injunction to block the sale. And they don't want to do that because they'll lose their money, and that's all they care about is money. So can I finish?
Yes.
The previous thought? Okay, so they accused me of disturbing behavior. So this is what disturbing behavior, this is the definition of disturbing behavior. Action or conduct that causes significant discomfort, unease, or alarm in others. Being unusually inappropriate or potentially threatening, indicating a deeper psychological issue or distress in the person. And examples would be verbal aggression, erratic behavior, or paranoia. And this is what they were accusing me of in that letter. Now, let me read, this is the HOA's, this is their last paragraph before they go to their addendum, okay? They tell a different story here that says, while the condominium trust clearly had no reason to believe Arslen was a risk prior to the unprovoked attack, and therefore had no duty to specifically protect their unit owner, Golub, from Arslen prior to the attack. So on page 31, they're telling a different story. On page 561, so who's the liar? Somebody's lying, right? That's an example that anything they put on paper or spew out of their mouths can't be trusted. What else? I got some more here. So all those in the case history, they lost everything. Everything they put on paper, everything they spewed on their mouth is a big, fat zero.
So you're out of your 15 minutes, but we did hold him over for a couple of minutes. So if you want to wrap up.
All right, there's no laws in the land, or bylaws in the land of Massachusetts that they can kick someone out of the house and find them into financial destitution. They're both intertwined like a dead vine, and their fruits of their vine is the fines, fees, and attorney costs. Their false notion that they can kick me out, thus their fruits are dead also, so they shouldn't get a penny. And also, under Chapter 183, Section 10, Subsection 5, fines must be reasonable. Do you think 23,000 plus is reasonable to fine somebody? I think not. And if I can win this appeals with prejudice and get this parasite off my neck, I'll sell my place. I'll put it up for sale immediately. I'll make one phone call as soon as, if I win, hopefully, I will immediately put it up for sale. If they can't interfere, they won't be able to file an injunction. If I win with prejudice, it will be over. It's all about money. For them.
So we've heard both sides' arguments, and we will take the case under advisement. I will say, because I've been here 9 years and I've been an attorney a lot longer than that, I hear two sides that could reach a deal if you wanted to, and you could, because they want you out and you say you're willing to leave, and you could enter into a contract that allows for that to happen if you can both be I don't even want to say reasonable. You both agree on what you want, so you should be
Yes,
able to
if
work
yeah,
that
if-
out. So you do what you're going to do. If you do reach a resolution and a settlement, then you should report that to us, and then we wouldn't have to decide this case, because this is a very high-stakes case, very significant interest for both sides. And I'm hearing both of you say that there's some ground that you could reach an agreement. But if you don't, then we will decide your case. All right?
Thank you, Lorna. If I.
You've done a very good job of
If
explaining.
there's no lien on my property, also.
What was
If I
that?
can keep my ledger at zero and I win this appeals, yes, I tried a settlement agreement.
If
It
you have an-
failed already.
If you have an attorney, it seems
Frankly, I
like,
don't trust them.
I know you don't trust them, that's why you have a contract that has provisions that make sure that everybody performs as they promise to perform. But if you reach an agreement, that's terrific. I think you'll all be happier. But if you don't, we will decide the case. Both sides have made their positions very clear, and we understand your arguments. And with that, that will conclude our session for today. Because hostilities are running high, I would suggest that one of you stay here in the courtroom and one of you leave. So counsel, would you like to leave? You'll stay, okay. So that'll give you an opportunity to leave the courtroom without any conflict between you and the attorney.
I have no
That's great.
inclination to speak to.
I appreciate that. I appreciate that.
It's the only person I want to speak to.
Thank you very much. Thank you to our staff for their help today.